Talk talk, yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace.
Hey y'all. Let me do my intro. Welcome to Legal Doc Talk. I'm your girl, your favorite paralegal. Thank y'all for sitting on this live waiting for me to start. I had to go run and do a mobile notary, and then I just finished doing an online notary. So let me go ahead and I got some invoice and everything. So give me just a second. But we're gonna tap right back into where we left off. But give me a second, and that give people time to come in and whatchamacallit. I had to stop and get my Sonic Ice too. So y'all won't hear me chew. Let me mute my mic. Y'all give me 1 second. I gotta go to the car and get my wallet. Oh my god. Okay, so thank you for tapping in. Thank you for tapping in. You're welcome. Now, one thing I hate doing is chewing ice, and y'all can hear me chew ice. I be getting on my boyfriend nerves with that. But stay away from. I'll try to. That's why I eat. Well, I shouldn't eat ice because that's a whole nother story. But hold on, let me. Sometimes I can't do two things at once. Trying to get my money because that's how I make my living. My 9 to 5 is doing freelance and mobile notary stuff. What the fuck? Okay. How to do that. And that's complete. What better send my money. That's why I start charging. So back in the days, I used to be so um lenient with people. Like I would draft documents and then have them pay later, or I would do notarizations and have look, I ain't trying to do all this. I would do notarizations and they would pay after I complete the notarization. But sometimes people be used to jip me out of my money. Like I would draft documents and they don't want to pay me. Baby, I had to stop that. So when I have people book for notary, I they gotta pay a booking fee. I used to feel bad, but now I don't feel bad because that's my time. Yeah, hold up. Let me go ahead because you about to give me my money. I just did this notarization. Ooh, excuse me. Generate. Copy link. Hold on. We're gonna get right into it, y'all. I gotta get my money first. Oh, let me tell you what, Rainy, for real. So for some strange reason, when I was pregnant, that was with all my kids, I could not drink water. And the only thing I could eat was ice, but then I ended up getting dehydrated. and they forced me to drink water. But I love water. It just made me sick. All right. That is the invoice. Thanks. I better not have to chase you for my $20 because I don't play. All right. What y'all doing? Hi, how y'all doing? All right, so thank y'all for actually tuning in and waiting for me. I was so ready to do this, get ready into this so we can finish the remainder of the motion for new trial. Thank you. Okay, that's good. He said thanks. So I'm gonna get my money. Flow state 2. Y'all, I don't even be knowing what this is. That's okay. Let me close out of that. I think I got too much open. I got my trading stuff open. I'll be trading by day. Okay, so it shows that, but it don't show that. Okay, that's good. All right, so where we left off yesterday was jaw dropping based off of the affidavit that Mike Howard actually submitted in support of the motion for a new trial. One thing I do want to clarify with everybody, these are not transcripts. These are motions. Motions are totally different than transcripts, okay? Motions is where you submit it to the court and you're requesting them to do something. Like in this case, we're requesting for a new trial, or we're requesting for the judge to step aside, or we're requesting for a hearing. Those type of motions have to be heard by a judge. Sometimes we can submit in by submission, meaning that we don't have to have a hearing, and they will go ahead and grant that motion. But majority of the counties, when it comes to like these type of motions, more than likely you're going to have a hearing. But I say all of that to say motions are different than transcripts. When we say transcripts is what the court reporter provides. I'm going to tell you this. So a court reporter is either in the courtroom, they attend depositions, or they attend hearings. And they are pretty much the individual that types down everything that's said. And everything that's said is on record. So when we talk about transcripts, the transcripts is everything that transpired at that trial. So there was a court reporter in that room typing away every conversation that was. So if a witness was on the stand, they were actually typing everything that witness say. If the prosecutor was talking, they were typing the prosecutor. If the judge was talking, they'll type everything the prosecutor. So everything, that is what a court reporter does. They I don't want to say transcribe in a sense. I don't know. I'm just trying to break it down in the simplest terms. That's what a transcript is. So the transcript is what the appellate team is needing in addition to the clerk's record. So everything that's on the register it's called register of actions, but we call it the docket. Everything that's on the docket, that is what the appellate court is needing, or the appellate team, I would say. So the transcripts are not the motions. All right, so I just want to get that clarification out there because a lot of people are confused about that. Motions are a request. Transcripts are words that is typed by a court reporter. All right, so hopefully that clarifies everything. I don't want to do that right here. Let me do that. Okay, so let me see. We have people on Legal Talk. We got people on the True Crime. Nobody on Facebook yet, and that's fine. So before I get into this, please hit the like button. I know if I have my mods in here, y'all already know what to do, but please hit the like button. Please share this video. And if you haven't subscribed to my channel, go ahead and subscribe. So that way, if I do put out any videos or I go live, you have notification. Now I have some people just be like, hey, I got to see what you're about before I subscribe. And that's totally fine. I'm not over here saying, you got to subscribe to my channel because y'all, look, I'll be trading, I'll be gardening, I'll be working, I'll be doing a lot. So sometimes y'all may not see me for about a whole 6 months. And that's fine because I do have a life out of this. But without further ado, let's hop on into this. Hopefully, did I share my screen? I didn't even share my screen, Lord. Oh, it does show the flow state screen. All right, we're gonna get into that. All right, there we go. Hold on, let me put my money up. If y'all want to become a notary, I do have a notary class. Okay, bam. So, thank you, Gold Digger. Hey, what's up? You know what? I don't even know. I can pin. There we go. And I will show y'all on my screen so that way if people are on Facebook as well, they can actually see everything. What else did I want to say? So I already talked about the difference between a motion and a transcript. What else have I heard today? I think that's it. But if y'all have any questions, definitely put them in the comments section. So we read that. We read part of the first 17 paragraphs of the motion for new trial. We read Mike Howard's affidavit that he submitted. And a lot of people are in my comments, especially on Facebook. I don't even know how to even describe it. Now, an affidavit has to be notarized by a notary. Okay. I actually had to go. No, I didn't. That was an acknowledgement. But it doesn't matter. An affidavit is a statement of truth. And if you lie, then that's like under the penalties of perjury. There is consequences for, lying. When you submit an affidavit that is notarized, so either you can notarize the affidavit or you can do a declaration. When we notarize a legal document, that makes it more authentic. I don't think that Mike Howard would have submitted all of those, statements that he made in the affidavit just for the fun of it. Now, we all can agree that what made Mike Davis enter? Who's Mike Davis? Oh, you talk about Mike Howard. That's who you're talking about. Well, I'm pretty sure that the appellate team asked him because the biggest thing was why didn't he testify? And we had all of these speculations. And like, I even had my I don't understand that's when you are in a criminal trial, it would only make sense for not only Karmelo to testify, but also for Hunter to testify. So I was like, something is not right. But then I started reading, just like if you watch the what was that? My Inside the Collin County DA's office video. If you guys have caught up with that, then you know that Bill Werski he's like the biggest bully, I would say. He's the biggest bully, honestly. And with that being said, I don't know if Mike Howard was intimidated by him, because based off of what I was reading in the other complaint, it's like Bill Werski would literally cause somebody not to make a living. Like, he will make your life a living hell if you cross him. So it's just like, I don't understand as to why Mike would even agree to that agreement with Werski. Like, were you scared? Did you feel like you was going to get blackmailed or blacklisted or whatever the case may be? I don't know. But I felt that he needed to, the appellate team needed for him to enter, because the whole thing, we're requesting a motion for a new trial. You have to have a legitimate reason as to why you are wanting a new trial. When they filed that notice of appeal, the notice of appeal is to start the process. And it's looking for any procedural errors that happened during the trial court. So when you are motioning the court, you can't just simply say, we want a new trial and that's it. You have to give them legal reasons with legal backing, such as the case law that they put in there, as to why you are wanting a new trial, right? Just like we saw in the motion to recuse. So the reason why Mike had to enter that affidavit in is so the appellate team can show the court, like, hey, these things was happening. This is why this happened. This is why this didn't happen. Okay? So I hope that makes sense. I really hope that makes sense. Do we know if Karmelo or his parents were notified or agreed to this side deal? Well, based off of what we read, it does state that Mike Howard had limited time that day to explain to them exactly what the agreement. Now, I don't know if the whole agreement as to them saying, hey, you say this and we say this, you don't say this, and you don't say this, so it won't open up this. I don't know if it was that in depth, but I do know that he had a conversation with him, because remember they said he was asking, Mike Howard was asking, and I hope I'm not talking too loud because I hate when I talk too loud, but I hope that but in the document it said that he was requesting more time. He asked Judge Roach for more time to explain to a 19-year-old what was on the table. So being that he only had limited time to explain, I don't think they fully got that picture. And then on top of that, they had the jury charge, which I have covered. And so you have these categories in which you have to put the situation in one of those three categories. So it's just like, dang, I really don't have an option here. Because if I do this or if I say this, then, and I'm thinking as to what Karmelo would probably say, because the conversation probably say, hey, if you testify, you can't say this, because if you say this, then it's going to breach our agreement that we have with the prosecution. Because the whole thing is they didn't want to open Pandora's box. They did not want for people to see, because if they would have asked the question about Karmelo, that would have opened the box to the Metcalf twins being exposed. I would say, I think that's the better term I would use. And Bill Werski and the prosecution team did not want that. That's the reason why Bill Werski said, hey, let's start clean. Anything on the outside, we're here. This is where we're going to start. We're going to start in this box right here. Anything outside this box is irrelevant. We're just going to talk about what happened under that tent. That's it. We're not going to talk about them being bullies. We're not going to talk about, the teachers, because y'all have to realize also it wasn't just Karmelo that did not testify. There were other people, teachers, that were going to testify to, at least tell them exactly how the Metcalf twins were. But then also it did mention something about Karmelo's cell phone and his school records, right? But the biggest thing that we seen was they were known for violence, they were known for bullying, and they got arrested for racist graffiti. Somebody on was it Facebook or was it YouTube? But they comment talking about, oh, I'm lying and I'm putting out false information. Let me tell you something. If Mike Howard didn't do anything, I know for a fact, because you can't get here without doing this. You can't get to trial without having some type of evidence. So I am sure they already had a request in for their records. Even in personal injury cases, family law cases, we sit there and we request everything, your arrest records, all the way from 10 years back. That's the maximum we go. Sometime between 5 to 10 years. That's what we request. We request all your medical records, billing records, driving records, school records. I don't care, whatever records we need, because we need to figure out what type of party we are dealing with. And we even get the same records on our clients. So nobody is excluded. But I bet you best believe that Mike Howard does have the Metcalf twins school records and their arrest records. Even though they're juvenile, because they committed these crimes as juveniles, unfortunately, that's information is not going to be in public. I don't care. You could search all up the internet and whatever. The only people that can actually get their hands on that Metcalf arrest record for the racist graffiti would be an attorney, either the defense attorney, the prosecutor, or the parents. That's it. I can request them. My attorney that I work with, even though he's an attorney, he wouldn't be able to request them. Nobody, except for the parties and the council that is on record. So he does have those records. It's just not available for public. That's why he didn't put him on the stand. I saw LP come in. What's up, LP? What is up? Hold on, let me see. It says, could the parents have stepped in and terminated the lawyers during the initial trial? You can. You definitely could have. we had a what was that? In March, we had a trial, and the our guy, the plaintiff, he fired us. Now this is gonna be his fourth law firm that he done fired. Like, bro, we can't get you no more money in this trucking wreck. This is what they have. Either you take it, because when you get to trial in the PI case, it's 50-50. Either you gonna win some or you ain't gonna get nothing. So he fired us. But you can terminate your lawyers at any part of. Now, do they recommend it? No. And you can't just say you're fired. What has to happen is they have to file a motion to withdraw, and the judge has to grant that motion. And either he can say no because, we're in the middle of trial or whatever the case may be, or he can say yes, and we're going to, I don't know quite how that would work in criminal, but I'm pretty sure it's the same way. Regardless, you still have to file a motion. Oh, you watching on the TV, LP? Hey. All right, so let's see. What's up? Mike Howard was ordered by Karmelo's appellate lawyers to file that affidavit for ineffective assistance of counsel outright. The appellate lawyers smell blood. Oh, yeah, most definitely. Because and pretty much, and that's what I was kind of saying in simplest terms. Like, this trial should not have gone the way that it went. Karmelo should have testified. You didn't do your due diligence. You didn't prep him like you should have, because you knew about this case back in April. I don't know when. I think they filed their notice of counsel June of 2025, if I'm not mistaken. That was plenty of time to get him prepped. But because Mike entered into this agreement with Worski in the prosecution, like, why would you do that? Why would you do that? Yes, like she said, y'all. Okay, before I get to, I don't know how many likes I got, but I'll get into it. Do you think the new trial will be granted? I don't know. And the reason why I'm saying I do not know is because I am basing, now his appellate team is bomb. His appellate team is bomb. I think they laid out everything as to why, and we're going to finish reading the reasons as to why they're requesting a new trial. But I'm optimistic. I'm very optimistic. If they can focus on the procedures that took place, I think they have a shot. So only thing we can do out there is we can just pray. And, this is not just about Karmelo. I don't care what case is in Collin County. You might find yourself in a case anywhere. And I think people will want for the courts to do the right thing. I'm just saying. Yes, he did. Yes, he did. I believe that. I really believe that. I trained to be a paralegal in Florida, took and passed the CLA, but couldn't get into the legal field in that capacity here in Chicago. Pivoted to IT, but in the legal industry. Oh, that's pretty cool. Yeah, I used to do cases in Florida. I just hate Florida laws. I told that attorney, I was like, look, I enjoy this, but I'm gonna have to let this contract go. Yeah, Florida's different. Cherry Block, that is crazy. If the attorney is not helping me, why should I pay for infected accounts? And Lord, my boyfriend will be calling me right now. Y'all give me a second, because if I don't answer, he gonna lose his shit. That man, he works in the oil field. All right, so I think Carmelo's attorney should not be in criminal law. A lawyer at the court law firm I work at said he's the weakest defense lawyer he's ever seen and should be avoided. He likely will. I said that yesterday. Like, you can say, oh, he's a good criminal attorney, but you have to look at what areas of criminal law you got. Like, I look, for example, you know what? Better yet, let's go to Collin County. Let's go to Collin County. I'm gonna show y'all a little something. So I'm gonna put y'all on some little something game. Y'all better hit that like, but I don't know where we at with that likes, but I don't know if I'm stalling or not. Hold up. What profile? Hold on. I gotta go here. I got so many. Hold on. Let me replace. I'm gonna just do the entire screen so I ain't gotta go back and forth. Thank you. Thank you. Yeah, hey, paralegal work. If you find the correct area of law, you'll like being a paralegal. What the hell was I doing? Oh yeah, Collin County. I'm gonna put not the courthouse. Damn it. There we go. What is for this madness makes you wonder. It just looks really Toby Shook is Worski's buddy. Yeah, and y'all have to realize, like, at the end of the day, these attorneys, they have conferences, y'all. Like, they be having what's called, okay, attorneys got to get professional development just like us paralegals and teachers and all this other stuff. So y'all don't think that they be sitting there chilling in Austin or San Antonio or wherever they having the next meeting at? Come on now. But to answer, so we're gonna look at what Mike Howard does. We're gonna look at what Mike Howard. Wait, is that his name? All right. So look at these. Damn. What was I trying to do? It's like 64. Can I don't think so. What I did is I went to Collin County and I typed in Mike Howard's name, and I am going to show you guys like the cases that he worked on. Like for instance, this one. Okay, this is just a magistration hearing. Hold up. Okay, I don't know what that one is for. Let's see, 2004. Da 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 da. Now I did this the other day and it was showing me some stuff. Okay, I'm looking at. I don't think really he's even had a case in Collin County. Hold up, what is this one? Oh, so this is a petition for occupational driver's license. Uh, let's see what's another recent one. Really, none of them. More like people who had DWIs. This is a protective order one. So as you can see, he hasn't had any recent cases in Collin County. What is this? 2025? I thought I saw a 2026 one on here. Let's see, we got 64 pages. And these magistrations, that's probably somebody getting booked in for a drunk driving or DUI or whatever the case may be. Magistration. I'm literally trying to find a case. Let's see. 2000. All right, so let's look at the state. Let's look at this. Assault. What's another recent one? Cesar Lopez Cruz. For this one, possession. And I'm looking up recent cases that he has done in Collin County. And I think I've went through all that, and I have yet to see a unlawful carrying of a weapon. Okay? Yeah, y'all see this? Let me do y'all a solid one. Let's go to Dallas County. Advance, filter, turn the name. I don't know if I can hold the attorney. Okay. Howard. Mike. Submit. You know what? I ain't got my money. Look, I ain't about to chase you for my $20. I'm not playing about my money. All right. Divorce, employment, divorce, tackling, felony 1087814. He haven't even had that many cases in Dallas County. Hold on, I'm just checking one more county. One more county. Shit, not that one. Yeah, and he really did. I really think he fumbled this one. Hold on, let me look at JP Court first, and then we'll go to Howard Mike. Possession, theft. Let me go to the most recent one down here. Driving while intoxicated, assault, deadly conduct. All right, so that was 2024. Let's see what this deadly conduct is. Okay, this person sentence deadly conduct 16 months of CSCD, and I think this is probably the biggest. This case was way too big for him, and whoever suggested Mike Howard, shame on you. Shame on you. So this is what he does: criminal defense, domestic violence, drug crimes, DWI, federal criminal defense, felony charges, misdemeanors, probation, property crimes, X crimes, thefts, violent crimes, expunsions, so let's go on the results and see. He said, I bet he lost that case too. Yeah, but I mean, as y'all can see, like, okay, we got aggravated robbery, assault. Now we have a capital murder and engaging in organized crime, murder dismissed. I want to know exactly what case that was. Oh, wait, hold up. It says view details. Our client's brother and killed someone in an argument. The victim's brother witnessed the shooting and wrongfully claimed that my client was present and is the one who provoked his brother to shoot him. Investigating fully, we proved that his cell phone signal was 45 minutes away at the time of case dismissed. I really want to know what case this is, because you dismissing cases. Then we have this one. Our client, that darn bully, he snores. Our client was facing life in prison. We cast enough doubt on the evidence that the prosecution offered a reduction in minimum offer, which was accepted. But I took y'all to Collin County, and he really didn't do anything in Collin County. So again, I don't understand. I don't understand. Yeah. So those is his cases. Oh, that's domestic violence. Case involving violence, domestic violence, drug crimes, DWI, federal cases, drug conspiracy, like this is his lane. Now we have another unaliving dismissed. Oh, it's the same thing. I really think they just did this website and just added this stuff in there. I'm not even gonna lie to you. Aggravated assault with a deadly weapon. Our clients and her boyfriend got into an argument, and our client grabbed a knife to protect herself. The police sided with her boyfriend and arrested her for aggravated assault with a deadly weapon. We were able to convince the grand jury to no bill or dismiss the case completely, leaving her eligible for a full expunction of her record. Yeah. So I don't know where he went wrong. Well, I do know where he went wrong. He got punked. In my opinion, he got punked. But yeah, so this is what he does. That's what he does. I've already done that, and the only thing that shows up is so he was arrested for an X crime, but he wasn't convicted. But that's all. But I do know you can't get your realtor's license with any of that funny stuff on your record as well. So there ain't nothing on Jeff. There ain't, trust me, I tried. If Dominique referred Mike Howard to the Anthony, but see, that's the thing though. Now I have done work with Dominique Alexander back during COVID, when it was the George Floyd. But I just felt that he should not have I don't know. I didn't hang around Dominique to, get all of his his past work, his past advocacy and all this other stuff. I just was like, okay, he's doing a good thing. I would love to work with him to see what we can do for the city of Dallas. But me actually living in Collin County, I knew the makeup of Collin County. I would have never suggested, and it's not even having a black attorney, or you need an attorney that is not scared to stand up to Bill and Greg. Period. Period. He should have been second chair. For real. Oh, thank you. Perfect. Okay, let's see. Thank you. Thank you. Mike Howard was named the best lawyers in Dallas by D Magazine every year since 2016. Okay, who thinks this was straight? Hey, let me tell you something. I'm gonna tell you about D Mag. Y'all want to know how this works? Do y'all want to know how the D Magazine works? They'll send you an email. And in that email, you will fill out some information and submit it, pay your little fee, and bam, I'm in the D Magazine. So y'all, please don't think that it's. I know some attorneys that were upset that they didn't get in the D Magazine, had another attorney, I guess, call the publisher or who else and say, hey, can you put this person, can you... True story, bro. True story. So just because they listed in the D Magazine every single year don't mean diddly squat. And this is from actually seeing with my eyes how they be getting in the D Magazine. Oh yeah, he was scared of the judge and he was scared of Bill. Bill is a big bully. Maybe first time with this judge. Probably so. Toby is a good lawyer. Don't get me wrong. Toby is a good lawyer, and I definitely want to see how this plays out in the Yellow BZ trial. I might do that. That trial is in August, so I might go to that one. But he's good. I've never heard anything bad about Toby. I'm not even gonna lie. Let me see. I heard Drew Anthony say that he was advised by Charleston White that. I know you playing with my emotions right now. Charleston White, first of all, that man is off his rocker. I'm just gonna start with that. And he came out and said that he worked with the popos. He got a rap sheet a mile long, probably more. And the allegations that came out, baby, I'm trying to get my hand on that. I might have to reach out to her because that's crazy. But Charleston White, I would not take any type of advice from Charleston White when it comes to getting an attorney. And if that's the case, he should have got the attorney that helps. But anywho's, Dominique didn't seem to be on their side. Dominique should not have put them. And going back to what I was saying, Dominique works primarily in the city of Dallas County. So you got to stay in your lane. Do you see Dominique going to Houston? No, because who has that on lock? Miss Candace. You don't see Dominique going to Houston. You don't see Dominique going to Denton County. There's a lot of stuff that has been happening. I never see Dominique anywhere other than the city of Dallas. So for the simple fact, you hopped in, made yourself an advocate for the family, had them interview for the whole nation, and now that's when it became popularized. That's when it became a national attention trial, because you put them in front of that camera. In the simplest cases that we have, even in a personal injury case, as soon as you sign up with us, the first thing I tell you is don't post on social media. Why? Because what we do is what I do in this discovery, I'm requesting all of your social media. I'm talking about your Facebook, your Twitter, your X, your LinkedIn, your Snapchat, your cell phone records. I'm wanting it all. I'm wanting it all. So by you sitting there putting them in front of a camera, that is a big no-no. You never want to interview. Even when simple car wrecks, we tell them, hey, we represent you. The insurance company has to go through us. You do not give a statement of any kind. They have to go through us in order to set it up. And we never, barely, I don't want to say, barely allow for our clients to give a recorded statement with the insurance company. But I say all of that to say, no way should that family have gone up in front of those cameras and told that story. That's it. All right, got that. Hello, they will publish whatever you pay them. Them and Voyage, but Voyage is like a Temu of the magazine. Oh yeah, he worked. Charleston Wright does. Now I don't know. Are you saying so does Dominique? He work with Coachella? I don't know. No, he is a troll, and I get. You know what? I give him his praise for that because he troll every situation. He don't care. Charleston White will troll every single situation. Cause you see what happened with Karmelo? That dude, hey, whatever makes him money. Because what do? People will go to his page to be entertained. They will go to his page to be entertained. Charleston White is a Fed informant. No black person should be listening to him. If that's true, Drew Anthony's ignorance. That part. I'm talking about all negative forces. So that's why we are pushing. If we can push for this, start the process over to have at least a fair trial. And if they do, they need to change venue ASAP, but bring it over here to Dallas County. Bring it to Dallas County. I think defense attorneys spooked the Anthonys to compile nothing on Karmelo's cell or family history can compare to. Oh no, exactly. I agree. He mentioned, what Karmelo saw in his household, in which hell, I turned out very well. Y'all see these up here? I turned out very well. My mama, baby, I didn't see it all. Because what black family don't be thrown down? You know what I'm saying? That does not mean that we come from a bad home. I cuss. Now my kids know I'm not their friend, but we good together. But one thing I've never done is I never fought in front of my kids. My mom and them, that generation. That's a whole different story. But you can't say that I came from a broken home, and that's why we're not going to do that. So people are trying to run with that too. All right, so let's get into this because I know what people are. So make sure y'all go hit that like button. So let's get into this. So I left off after reading Mike Howard's affidavit. So let's get into this. Now, this does say 193, but it's only the actual motion is about 60 pages, and then the rest are exhibits to support this motion. All right. So what I got? I got water. I got some water here. All right. Let's get into this, y'all. The forbearance had a purpose. The payoff was to come in the defense case. Under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent, the defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence, and as trial counsel has sworn in this case, the defense would ordinarily depend on the defendant on account of his perception of the threat. On Monday, June 8th, the final day of evidence, after the defense had spent voir dire, it's opening the entire cross-examination of the state's case and the first day of its own case, honoring that the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant, and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. Because remember, Bill Worski was trying to say that Mike Howard stated in his opening statement that Karmelo played chess. And if you think about it, that's more like, okay, if you think about somebody playing chess, you automatically think, okay, they're smart, they're intelligent, blase, blase, blase. Then that kind of opens up the room for other stuff, other character stuff to come out. And which Bill said, if that happens, that would be a breach in their agreement. And if Bill was to say, okay, he breached our agreement, the judge wouldn't been like, okay, well, because the agreement, it was just an oral agreement. It's not something, there was no motion in limine filed, there was nothing, okay? And the judge is pretty much saying, I can't sit there and say, okay, yes, you breached the agreement. No, he has to now decide based off of the rules. You can't base it off of the agreement because the agreement was supposed to be an agreement in the first place. But at the end of the day, Judge Roach said, okay, by him saying he played chess, that didn't open up the door for anything. But anywho's, the court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, and understanding that throughout the months the defense relied upon it existed as no record because it had been reached and presented to the court off record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted 10 times, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state witnesses, and at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. Y'all hear that? Pre-approved. The state, for its part, called no punishment witnesses and offered none of the extra offense and character evidence cataloged in a 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th that the agreement would operate. And that's what he stated in his affidavit, Mike Howard did. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding, as the state itself had repeatedly described it, he would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on its own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening, cross-examination, expert designations, or decision framework that have followed from the understanding. All this to say, because we relied on the agreement that Bill Worski put forth At the end of the day, he's just saying he fucked up. In layman's terms, he fucked up. He took the word of Bill Worski and jeopardized his whole defense for Karmelo Anthony. And it wasn't just that, because like I said, yes, Karmelo Anthony's testimony was vital, but also were the expert witnesses, the expert that talked about his epilepsy. They had witnesses or the teachers to talk about the Metcalf's behavior. He had other witnesses, school-aged witnesses that can talk about their character. But all of that was shut down all because Mike made this agreement. And Bill Worski, being the bully that he is, he knew what he was doing. Them old boys were on code. Senator's son involved. They were friends, judge instructions, backroom deals, and I'm still waiting for the coroner report, cause of death, and the clear video would clarify. Yeah, all of that. Let me tell y'all something. If a motion for new trial does come, eventually everything will come out. Because I'm sure that they have it. They just didn't want to present it as evidence. I don't know. I really don't know how, and that's probably why. He probably say, hey, well, he ain't had no choice to not to offer this affidavit in this motion for new trial. No, you fucked up, and you need to tell us everything that happened as to why it went down the way that it did. Simple. All right, the expedited schedule. Saturday court in 10 minutes to decide. Woo, man. Hold on, let me go because I done forgot what section we was on. All right, this was just the background, the hearing, the minute order, access operation, inside the courtroom, day by day, the excluded public, the unrecorded agreements. And now we're on the expedited schedule. Saturday court in 10 minutes to decide. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense begin calling witnesses immediately upon the state's resting, so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order, and he didn't want to do that. They have it set up to where we call this, it's kind of like you're building up that suspense. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties' understanding described above and set out fully in Part 4 below erupted on Monday, June 8th. The final day of evidence. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel. A 19-year-old through it and denied counsel's request for additional time. Where were the objections? I wish I could get my hands on this transcript, because did you not object? Like, why? You gotta fight harder. Like, I'm not accepting that. You're gonna have to throw me in contempt. I'm not accepting that. You're giving me 10 minutes to counsel a 19-year-old about making a decision. 10 minutes. And then I asked for additional time. Hell, 10 minutes, not 20 minutes is not even enough. Mike Howard should have prepped him and say, okay, these are the possible outcomes, and broke down so he could understand. I told y'all last night I got a 20 and I have an 18-year-old. Me telling them, they're going to be like, what? They're not going to understand, because they've never been in trouble before. Thank God. But a 19-year-old who is facing up to 99 years in prison You only give us 10 minutes? I would have been held in contempt. Because that judge would have got cussed the fuck out. The defense rested that day after the shortened session, and the jurors were sequestered overnight. Oh, in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. Oh, what? And I wonder if they said if that's in that transcript, baby. If that court reporter got that, oh my gosh. On Tuesday, June 9, 2026, the court delivered its charge, and that's the jury charge that I read. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence, argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and and the deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. Mm-hmm. So it is in the record. So that little comment that the judge made, like, if y'all don't come to a verdict, then y'all gonna be there till Tuesday away from y'all family. All of that is in the transcript. I like that. After the verdict, the sealed file, the missing record, and the televised defense of closure. Remember, we are reading the motion for a new trial. So they are asking the court for a new trial, and they're providing reasons as to why they need a new trial based off of the procedures that took place during the trial. All right. The secrecy outlasted the verdict. Trial counsel withdrew on June 10, 2026. Appointed appellate counsel was then replaced, and present counsel were substituted in on June 23rd. All while the 30-day deadline for this motion ran, the reporter's record remained wholly untranscribed. Y'all hear that? The reporter's record remained wholly untranscribed, and the pleadings and case file set on the court's chambers rather than in the district clerk's public record, sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file will be sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in the chamber. So why was that file still in the chambers? Now, I have been to enough. I'll get to you perfect. I'll get to that. I have been to enough criminal trials to know as soon as a case wraps up, they hand their file over to that court administrator, and that court administrator does their thing, what they need to do with the files. I've seen that with my own eyes. I do not understand as to why that record was still in his chambers versus going to the court administrator or the court clerk that will actually give it to the district clerk, because they have a whole filing system. See, stuff has to be docketed. So the stuff that we show y'all on the docket where you see motion file, order file, subpoena, all of that has to be entered in on the docket. So again, why was this? So let's look. Exhibit, what page are we on? We're on page 11. Let me write that down. Before I get to that, I'm going to answer your question. So why did Mike Howard agree to this? The Metcalf twins character stuff is far worse than Melo's. Be fucking lawyer and overcome it, period. No, I agree. I truly agree. And he could have won that case based off of that. But the thing is, what does Bill have on this man? Tune into the Inside the Collin County DA's office lawsuit that I read. Because Bill Worski, I think, This man got some type of power. I don't know. But he will blacklist you in the state of Texas, it seems. Thank you for the $5. I don't even know what is that. Is that a super chat? It's something. It is something, but definitely thank you. Ineffective assistance of counsel. That's what it is. That's exactly what it is. That means that the jury resorted to a rush to judgment out of yes, they did. This is going to be federal because of this behavior. We shall see. Because if it doesn't work out here, and it will go from the Fifth Court of Appeals to the Texas Criminal Appeals Court. But we don't know. It's just the best. Now, if they broke any federal rules on that level, then it might become a federal case. But right now, we're just dealing with Texas code, Texas rules of criminal procedure and stuff like that. Judge Roach won't talk about any of this in his interview. Oh, no. He ain't. All right. Remember, we're on page 11, but we're going to take a look at these exhibits. So let's see what exhibit 2. That's why I like to look at the exhibits as I'm reading this, so you guys can have a better understanding. All right. Okay, so this is this is what you guys see. Now, for us legal professionals, we can log in and we can see more, and we can actually access certain documents. But this is what you guys see. So this is the docket that you guys see, depending on which site you go to. I go to 2. Oh my God, I'm trying to get. All right, so the jury charge, bond discharge, jury questions, judge list, appeals. So y'all put that in, but yet the file was sitting on the desk. So they put it in. But when the attorney requested it, it was in the chambers. So y'all put everything on the docket to make like, okay, the file was transferred, but it really wasn't, because it was sitting in the judge's chambers. And I think the other exhibit they mentioned was 11. Certification of undersigned counsel regarding June 29th conference and the oral sealing of the court file. Okay, let's see what this says. All right, so this is this is a certification by Mr. Russell Wilson in regards to the document or the file that was sitting in the chambers. So y'all listen. Can they file a lawsuit? I mean, technically no, because we're already in the lawsuit. But who are you talking about? Who can file a lawsuit? All right, so let's get into this. If y'all have not, please hit that like button and share. If you are on Facebook, definitely share and like. On my true crime channel, I see people on there. Definitely like, share, and subscribe. All right, so this is the certification of Mr. Russell Wilson. If you do not know who Mr. Russell Wilson is and what he is capable of, I need for y'all to go look him up. Everybody use Google for everything else. Y'all need to go look him up. He's badass. I am one of the attorneys of record for defendant Karmelo Anthony on this post-conviction motion for a new trial in the above captioned cause. And I am licensed to practice law in the state of Texas. I was substituted in as counsel on June 23rd, 2026. I make this certification of my own personal knowledge, and the facts stated below are true and correct. On June 29, 2026, I attended a conference with the court in this cause. Counsel for the state and co-counsel for the defendant were also present. At the conference, the court advised the parties that the entire court file in this cause had been sealed by oral order. The court advised that the file was, in essence, maintained as a paper court file that was not available to the public, and that it was kept for inspection in the court's chambers rather than the district clerk's public file. So in the courtroom. So in the courtroom, you have the judge, the court clerk, and the court administrator. Okay. They have to take that file and they have to give it over to the district clerk, and they're the ones that upload all of the documents, they scan them in and they docket it. That's what they do. Oh, and that's on Clack it. If you don't know who Russell is, you're gonna know after that. This emotion party, we can say it again. All right. Um, all right, so number 4, the court advised that there was no written order sealing the court file. No public notice, open hearing, or findings accompanied the sealing, and I am aware of no written order authorizing it. Oh, because on there, I don't even see it. I didn't see an order for sealing it. He's right. That's why he showed the public docket to show you guys that there was no order ordering for those records to be sealed. Bam. The court would not permit me to review the court files unless I agreed not to disclose the information contained in it. And the court would not provide unconditional access to the file. I responded that I could not agree to withhold information that I had not seen yet. I left the conference without reviewing the court file, and I advised the court that I would be back in touch with it. I informed the court that I intended to file a motion for a new trial. I further advised the court that I had not yet decided whether to file a motion to recuse. See, this is where we're going because stuff is not making sense. Stuff is not making sense, but I'm letting you know the notice of appeal was already filed, but we are still within that 30-day time period where I can file a motion for a new trial, which means that I need those records. I need to review what's in that file. I can't do my job effectively without knowing what is in that file. And this would be information from both the state and the defense counsel. The certification recounts certain statements made and events that occurred at the conference. It is not intended as and does not purport to be a complete recitation of the discussion with the court. It is offered for the limited purpose of establishing the necessity of an evidentiary hearing and of addressing the availability of the court file to counsel during the period for filing defendant's motion for new trial. I declare under penalty of perjury, See, when you put that, I declare under penalty of perjury, so you can do this, or you can actually have a notary notarize it. But yeah. All right. That's interesting. All right, so let's go back to page 11. All right, so we did that. All right, 22. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people can hear, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it is important to me to provide transparency." And in a public letter on June 17, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial, at minimum raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. So, all right, let me take y'all. We ain't going to go into the transcripts because I think people already know exactly what he said. But we're going to I want to look at that written statement. So that's Exhibit 5. And we're going to look at the public statement that he put on the website. So let's hop down to Exhibit. So y'all see how this flowing? I got to keep it flowing so y'all understand. I don't want y'all to lose me. Because I don't think people have seen the written statement. So we know that he did the the camera interview with WFAA, which is Channel 8 out here, I believe. But he also did something with Dallas Morning News as well as Fox News and USA Today. USA Today. Let me see. Before I do this, let's see. And y'all, hey mods. Now I don't want y'all to kick out anybody, but if they get disrespectful, calling, being racist, definitely get their ass up out of here because I'm not tolerating that. Russell stepped into the national spotlight as the lead attorney representing 19-year-old Karmelo Anthony pro bono. He did. Yeah, Russell will be all up in the federal courts too. I know. You are ridiculous. He's guilty. Let it go. How about, you know what? Here is my you have one person listening to this. Well, Bookie, but you is on Facebook. Come over here to YouTube and you will see. But I don't care if it's one person. I don't even care if I'm talking to myself. My purpose is to read these court documents and break them down so everybody can actually understand them. So, Williams, if you don't like it, what you can definitely do on Facebook, you can actually keep scrolling, or you can hit them three dots and you can put not interested, and I won't show up on your feed, Bookie. But okay, all righty. So why are they so hell-bent on an agreement to not reveal? That's a very good question. Honestly, you have one chance to prove your case for your life. That sad part is we trust someone in that type of field, doctor, dentist, to do what's right, and just the person retaining their services. Yeah, you're right. And see the difference with when we're dealing with when you're dealing with criminal law, two things can happen. Either you can file for an indigency. I gotta say it slow. I'm country, so I'll say it all wrong. Or you can go to legal aid and they can provide representation, or you can get a court-appointed attorney. But if you want legal representation, you got to pay up front. So it is sad when you pay for these lawyers and you have even with family law, I see people pay about $50,000 and their case. I'm like, what the world? And little old me just draft what I know how to draft and file it, and boom, bam, bam. Their case is good. Their case is good. So it is sad that they sit there and spend all this money and they're not fighting for them. Russell Wilson is a bad dude. He's big time heavyweight litigator. He heard the Not Guilty boy speak highly of this guy. He's bad. Oh yeah, Andrew and Michael, they are awesome. They are awesome. I'm glad to be in a city where we got some awesome criminal attorneys. Melo's attorney, the DA, and the judge all violated Melo's 5th, 6th, and 14th Amendment rights on many levels. This is destined for federal courts. Oh, yeah. When you put it that way, you're right. You're right. Is exposing everything those unlawful DAs and this attorney. He's trying to make sure he got reelected. Man, what? And another thing, what I've noticed, like Greg Willis was elected DA in 2011, and a few years after, or probably, I can't remember, I have to go back and read that petition. Bill Worski he came into the DA's office, but nobody since 2011 has ran against Greg Willis. And it's just like, why? Because of the makeup of Collin County. Like, I really wish somebody can go, like Dallas County done change DAs. Like, I'm like, what is going on in Collin County that these are people that are afraid to run up against the DA? I don't know. All right, so let's look at this written statement right quick. Let me see. Judge John Roach tells me he released the evidence because I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. So that's what Brooks said. That's what Brooks said. All right, now let's go over to, it's right here. The thank you letter. So this is what he wrote on June 17th to the members of the Collin County family. What? Okay. As a presiding judge of the 296th District Court in the recent trial of State of Texas versus Karmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its fundamental responsibility, ensuring the fair, orderly, and secure administration of justice. Trials that attract significant public attention require extraordinary preparation behind the scenes. While much of the public focus is naturally directed toward what occurs inside the courtroom, the truth is that the work of administering justice depends upon the collective efforts of many people, most of whom serve quietly and without recognition. I extend my deepest appreciation to the Collin County Commissioners Court for its unwavering support and commitment to ensuring that the resources necessary to conduct this proceeding were available. I'm equally grateful to our Budget Department, Information Technology Department, Human Resources Department, Auditor's Office, CSCD, which is the Collin County Sheriff. Is that Collin? Collin Sheriff? Shit, one of them. Public Works and the Facilities Department, each of which responded to challenges with professionalism, flexibility, and the willingness to do whatever was necessary to meet the moment. Offers special thanks to the district clerk's office and the jury services staff for their tireless efforts in managing the enormous logistical demands associated with jury selection and trial administration. Their work ensured that citizens called to serve were treated with dignity and respect throughout the process. I also wish to recognize the extraordinary efforts of the Collin County Sheriff's Office, whose deputies and leaderships devoted countless hours to maintaining the safety and security of all participants while preserving the integrity and decorum of the judicial process. My gratitude extends to the Texas Department of Public Safety and to our law enforcement partners for, all right, so McKinney, Allen, Frisco, and Plano police departments, good to know. Their collaboration, planning, and the visible presence provided reassurance and protection to all who entered the courthouse. I likewise thank the Collin County and McKinney Fire Marshal offices for their expertise and assistance in assuring that appropriate safety protocols and emergency preparations were in place. I also I would also be remiss if I did not recognize my fellow judges of Collin County. Throughout these proceedings, they modified already demanding schedules, adjusted their own dockets, and accommodated the unique needs of the case without hesitation. They understood that ensuring the orderly administration of justice in one courtroom often requires sacrifice and flexibility throughout the entire courthouse. Their willingness to loan members of their staff, including their invaluable bailiffs, provided critical support and exemplified their collegiality, whatever, professionalism, and spirit of service that define our judiciary. I'm deeply grateful for their friendship, cooperation, and steadfast commitment to our shared mission. Most personally, I want to recognize the remarkable staff of the 296th District Court. Their long hours, attention to detail, patience under pressure, and steadfast commitment to public service were indispensable. They represented this court and this county with excellence. Finally, to everyone else who played a role, whether through planning meetings, operational support, communication, security preparations, technical assistance, administrative coordination, or simply a willingness to answer the call when needed, please know that your contributions matter. The public often sees only the final product. I had the privilege of witnessing the countless acts of professionalism and teamwork that made the final product possible. The administration of justice is one of our community's most solemn responsibilities. The trial demonstrated that can be accomplished when dedicated public servants from different offices and agencies work together toward a common purpose. Regardless of title or assignment, each of you contributed to ensuring that the process was conducted fairly, safely, and with dignity our citizens deserve. It has been one of the great honors of my judicial career to serve alongside individuals of such character and professionalism. On behalf of the 296th District Court, thank you for your service, your sacrifice, and your unwavering commitment to the people of Collin County. With sincere appreciation, Judge John Roach. You know, it's very interesting that he, y'all, I kid y'all not. So you address this, not saying that this is not important. There is shit going on within y'all department, but not even the department, within that whole Collin County government system. And this is what you put out. I'm truly disgusted because there were women in that office getting sexually assaulted, and they are sending out emails to everybody, the district clerks, the county clerks, the commissioner's office, everybody. And do you know those people ignored them? But you can sit here and address this. I'm not understanding. Thank you for gifting Sherry Blossom, and Peekaboo got her membership. Awesome. Awesome. All right. Let me see. Keep doing what you're doing. You're great at what you do. Just thank you so much. Thank you for tuning in. They railroaded him. Exhibit 10 explains I'm sick behind Exhibit 10. Yeah, we actually read that. We read that yesterday. And that's truly sad. Mike Howard should be truly ashamed of himself. Yep, we already broke that news last night. Yes, what's going on in Collin County? Willis and Worski have their position for power. Collin County doesn't seem to have a problem with their DA breaking the law. Bam! $1.75 million was paid to those women and man, because he actually stood up for those women. And Collin County paid them people. They had to split the 1.75. Yes, it's based on the true story because my old firm did it and my bestie was the paralegal on that case. So that is a true story. And they don't want y'all to know that. So when I say that DA's office is corrupt, they're corrupt. When I say that whole county don't give a flip about any of the, even Bill Worski out of his mouth. I don't know if I already covered that in the videos that I did for Inside the Collin County DA's office, but Bill Worski from his own mouth stated that he don't care about the victims because they already dead. He don't have to hear for them. He don't have to do nothing. Those was his words that came out of his mouth. Bill Worski don't give a fuck about the victims. That's pretty much what he said. I need to chop that up and make that a real, like for real. Everyone, Judge Metcalf and prosecution have stopped talking since the new legal team. It's not that they stopped talking. Now, the Metcalfs have not stopped talking. That they have not. Now, Judge Roach, on the other hand, I think he probably realized what he did because I can't fault people for not knowing the law because I'm in law, but the internet is to your disposal, right? If you simply type in, well, why can't a judge say anything after a trial? I'm pretty sure something might pop up saying because that is the time period where a motion for a new trial can be filed. If you utilize Google and AI, right, they use AI for everything else. So that's more than likely why Judge Roach, you ain't heard from me because you thought he would rebuttal all this, but he ain't gonna. He's like, okay, I see what's going on. Yeah, he knows it. He got sanctioned before in 2018. All right. So like it's like Judge Roach was giving a shout out to. No, he was giving a shout out to everybody, baby. He's like, hey, this is my last case. I'm done. If you are so, let me, and this is what, let me see who I got on Facebook, and because this is mainly for them people on Facebook. If he was so, not saying that he wasn't smart, but if he knows the law inside and out, then he would have known that there is a time period in which a motion for a new trial would have been filed. I don't know if he didn't think, but I can't, there's no excuse really. Because as soon as that notice for appeal was filed, that was on the 10th. So you telling me your court clerk, because what happens, and I'm gonna show you how this works. When I file a document, it goes to the district clerk's office or the county clerk's, whatever, if I'm filing in district court or county court. That filing is then sent to the respective court. Whatever it is, depending on what it is going to be seen by either that specific court clerk or the administrator. So what you're telling me is when that notice of appeal was filed, your court staff didn't tell you that a notice of appeal was filed, because you're the best judge in Collin County and you know your stuff, you would have known, oh shit, okay, a notice of appeal was filed, so I need to wait for this motion for a new trial to come in. That should have just, like, the light should have flickered. The light should have flickered. So that's no excuse. And maybe he did know, and he's like, hey, I'm about to be up out of here anyway. Who knows? But that just wasn't the smartest thing to do. Maybe he don't care if he gets sanctioned again. I don't know. I really don't know. That was a good old boy and wink wink. Da-da-da. Oh no, I'm late. Oh no, you're fine. Good evening. Good evening. Good evening. They didn't expect the team. No, they did not. They underestimated him. Let me tell you something. We're not fighting the conviction. We're fighting the process in which they did things, because it could have been a different outcome. That's what we're fighting for. Welcome, Michelle. Thank you. Dabadoo. Is that what you Dabadoo? Hey, Dabadoo. Collin County is a knuckle dragging but sophisticated, unreconstructed sundown town. Families stop chasing white folk around and integrated with them. We're sacrificing our kids for best. Let me tell you something. That is exactly, because when I got married, I ended up getting me a house in Little M, and I was on the border. So I was Denton County. Across the street, that was Collin County. Then got a divorce, moved out the house. Then I moved to Prosper. In my head, so both of my my younger kids were born in Frisco. But in my head, kind of looking at the school that they went to, like, my church is in Denton County. So I still go over there every now and then. But looking at the school system, even with my children, because my son had one incident, I was like, nah, we got to get up out of Collin County. Two counties I won't ever move back to is Denton County and Collin County. Definitely will never move to Tarrant County. I'm good with here, but if I want some land, I got to go south or east or possibly west. I don't know. But I won't live in Collin County. And believe it or not, I actually did history over here. And even the land that I am on was actually land that was given to the slaves in this area. And who came in and swooped it all up? There is like probably 5 minutes up the street from me, which is Plano. There's a community of African Americans that have been there. I think if it was not their grandparents, were actually slaves, and that land was passed down. And luckily, the city of Plano actually gives them, I forgot what it's called. I'll probably remember here in a second. But they gave them that area. But y'all have to realize we live in Texas, and I have been here since 1992. I'm talking about I could be in Denton County and see clear across to McKinney, which is Collin County. There was nothing. Now it's and over the years, it was more of a melting pot. But then over the years, you see the Hispanics and the black people go further south. That's why they be like, if I say I live in North Dallas, they be like, what? You know, people think you bougie. But I've seen wealthy black people live in Duncanville and DeSoto in some big ass mini mansions. Because being a notary, I can travel wherever the hell I want to go in Texas. And I have seen it with my own eyes. But the fact is, it's like they are pushing us further south while they take over these areas. Frisco, La M, McKinney, Anna, Salina, hell, did I say Frisco? Plano, hell, all of it. But yeah, so me personally, I just want me some land so I can build me a big garden and have some farm animals and we be that. Ego and arrogance, some people cannot help themselves, roast gal, and that's all he did because he already knew this was a big old controversy. CW is a plan. Who's CW? I don't know who CW is. Maybe I'm tripping. Judge Roach thought that Carmelo's attorney was going to be a court appointed. And I tell you, I ain't knocking court appointed attorneys, but baby, let me tell you something. You retain you an attorney. Oh, Dabadoo is the name of your daycare? That's dope. Oh, that's dope. Yes, corruption at its finest. Did the judge do those interviews on purpose? I'm guessing he wanted to be recused from this case. I mean, well, that's a good question. That's a good question. But that's why I said he's on his way out. He probably really don't give a flying flippers. Collin County sound downtown. I don't mess with Collin County. I don't mess with Hill County. And you go east, like if you go northeast, so you like got Collin, then you got Hunt County, all up there, all the way up to the Panhandle. I don't mess with none of them. None of them. My problem with Big Mike is dang negotiating skill. They wanted nothing more than to keep the Metcalf's BS out of court. Mike shouldn't have taken that opportunity to negotiate charges in a plea deal. You are so correct. You are so correct. There, I would have been held in contempt because I'm not. I have to fight for my client, and you did not fight for your client. I never had an issue with Collin County until now. I'm ashamed to say I live for, and it is. Let me tell you something. It's the little itty bitty. If you go on Facebook, hello, Ellie, and go to Collin County. I gotta go to my regular account. Hold up. It's one of those Collin County groups. Baby, when I tell you they some racist motherfuckers in there, baby, what? Like there was a lady with a hijab on in the grocery store. Somebody took a picture and posted it in the Collin County group and said, what the fuck did they say? Oh yeah, they said, tell me what you see in this picture. I said, a lady shopping. And they were trying to be funny. Right now, Collin County is fighting for now. Everybody, some people do have a little bit of discrimination, racial, whatever you want to call it, and they feel some type of way about a group of people. So anybody of Muslims, right? They are wanting to buy 400 acres. Now it's land that is northeast of us, right? And they want to build a community. But in that community, they're going to have schools, they're going to have jobs, they're going to have houses, they're going to have apartments. And they said, it's not like it's a cult. It's not like David Koresh, how he was in Waco. No, they're having businesses and homes and stuff, an area that they can grow up, like kids can grow up, up 400. But they're saying people like me, if I want to go live over there, if I wanted to go, well, it's open to everybody. And Collin County is fighting so hard right now to keep them from doing this. Like, I mean, they are, y'all have to read about it. Y'all have to literally go and read about this. And they're trying so hard to keep them out of that county from purchasing that 400 acre to so they can establish them a community. And I had this, it wasn't even an argument, it was a discussion with my boyfriend. And the first thing he said, "Oh no, they're trying to take over." Why would you say that? Why would you say that they're trying to take over? Why is that the first thing that comes to your mind? But and do y'all know, if you look, there are cities that's, hell, Frisco was not this big. I tell you, I've been here since 92 when I was a kid. I was a teenager. Probably not even a teenager yet. In 92, and Frisco wasn't big. Little M, there are some towns that weren't even created. And somebody say, "Hey, let me buy this land over here and let me build a community." So it was okay for them to do it. But now that you have a group of individuals who want to come in and establish their own community, you're not allowing them because you're racially profiling them. But yet Elon Musk can take his ass on the south of Texas, buy some acres of land, do the same thing that they are doing, but it is okay for him to do that. That's not okay. That is not okay at all. I was wondering, how can we figure out what happened to all the GoFundMe money? I'm starting to think the Collin County took it. No, with GoFundMe, whoever set that GoFundMe up, you have to put a bank account on there. So whoever bank account that money went to, either one, they probably, whoever create, I don't know, I didn't see it. And me personally, if I don't see it come out of your mouth, I'm not putting my money towards nothing. But that's a very good question. I don't know. Sent the money back to the donors. Oh, I hope they did. And if they did, that's good. Trick them into hiring. That's how they legally stole the child. I'm gonna do some research because I really want to see that. He didn't think he would face a dream team. I don't think but y'all have to understand, this boy is 19 years old, probably never been in trouble in this magnitude. He didn't understand. Land stolen from foundational Black Americans by whites and Latinos is why we need reparations. Oh my gosh. I be telling my boyfriend the same thing. He was acting like they had something. No, I promise you, I need to figure out about Mike because something ain't smelling right. Mind you, women like her also found Karmelo guilty. All right, so let me. All right, so let's get back to this. So that was the exhibits that he gave. Wait, did I do? Oh yeah, the interview and whatchamacallit. All right, so let's. All right, ba-ba-da-ba-da-ba-da. All right, so 2 days after imposing sentence, the trial judge gave a televised interview. Oh, wait, did I already read? Yep, I already read that. All right, so because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file has been held in chambers rather than the district clerk's public record, the recitation above is drawn from the indictment. The court charged the public docket and the court's own orders and public statements. The attached affidavits and declarations and counsel's knowledge, defendant will offer evidence at hearing and support on the grounds timely raised herein. And y'all know what's crazy? So I didn't send a request to get the copies of this motion for retrial and motion to recuse from my business email. I sent it through my attorney email, the attorney that he furnished me to use when I'm doing work for him. And so the clerk emailed me back and she was like, "Well, I can give you a copy." Hold on, what they say? I'm gonna tell y'all exactly what I said. But see, I have my ways of getting. I'm gonna find a way to get that copy. Hold on, what they say? Wait, hold up. Oh shit. He didn't. Oh my gosh, there's a deposition tomorrow, and you didn't prep her. Okay, let me go on here. See, I'll tell you. Where's that damn email at? It said DC, 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 D. Did I send it from there? I probably didn't. My dumb tail. Nope, I ain't sent it from my work. I should have. It says our office can provide you with an electronic copy of the motion to recuse and order. As for the motion for new trial, I am unable to provide that to you as it is sealed and cannot be given out. Why is it sealed? And that's a lie. It ain't sealed because other people have gotten it. So I thought that was interesting right there. Procedural background, timelessness, and jurisdiction. On June 9, 2026, a jury found defendant guilty of murder, and on the same date, the court imposed sentence in open court assessing punishment at 35 years confinement in the Texas Department of Criminal Justice Institutional Division. On June 4th, 2026, the trial court signed the certification of the defendant's right to appeal. Although that certification issued before the verdict, the judgment of conviction was rendered and sentence imposed on June 9, 2026, and the notice of appeal followed. On June 10, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as that cause number. See, and for those who's tuning in that don't know how the process works, he's telling you exactly how this played and how the judge did something that he wasn't supposed to do during that time period. Because by him filing that notice of appeal, that means that there was a proceeding pending. On June the 10th, I already read that. On about June 11, 2026, after the verdict, the sentence, the certification of the right of appeal, and the filing of the notice of appeal, the presiding judge gave a televised interview concerning this case, which aired on WFAA TV Channel 8. The motion is timely under Texas Rule of Appellate Procedure 21.4a, being filed within 30 days after June 9, 2026. The date sentence was imposed in open court. The court retains authority to consider and rule on this motion through the 75 days after that date, which is June 9th, and a notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in the Court of Appeals. Pending. So what the judge, and we gone through this in my reels and other videos, he cannot give an interview. It's not ethical, and it is a violation. You violated Canon Code 3B, which states that if there are any pending or impending proceedings, you can't do that, what you just did. What? You donated $500. So of course, if anything else is corrupted, the money is to oh yeah. Doc, what did the clerk of court do? Oh, okay. All right. Because sentence was imposed in open court on June 9th, 2026, the 30th day to file this motion is July 9th, 2026. And the 75th day falls on a Sunday, which means that usually they do it the following. Okay. They're going to do it on the, okay. So you either pick that Monday or you pick that Friday. And we always pick the Friday versus the Monday to just ensure that we get stuff in on time. And so they can't come back and be like, well, y'all didn't file it timely. You got me messed up. Defendant requests a hearing and ruling no later than Friday, August 21st, to avoid any dispute over Rule 21.8's deadline. Defendant is presenting this motion within 10 days of filing, as required by, as Rule 21.6 requires, and contemporaneously requests that the court sign the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and the court may rule within the time Rule 21.8 permits. Contemporaneously with this motion, defendant is filing a motion to recuse the presiding judge, in which we read yesterday. Because Rule 18A of the Texas Rules of Civil Procedure governs recusal in criminal cases, and they reference Arnold versus State, defendant requests that the evidentiary hearing on the motion be conducted by the judge presiding after recusal motion has been referred and resolved in accordance with that rule. This motion is supported by affidavit. Because it raises matters outside the trial record established by the attached affidavits and authenticating declarations, and is timely filed and presented, defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one. And they quoted Reyes, or cited, I should say, Reyes versus the state, Rozelle versus the state, and Hobbs versus the state. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable from the existing record that, if true, can entitle defendant to relief. That is especially so here where the reporter's records had not been prepared. The official court reporter has advised counsel that no portion of the trial has yet been transcribed, so that the relevant proceedings cannot presently be reconstructed from any existing records. So, and you know what popped up in my head is, remember how I put that reel out yesterday about there's something going around stating that the appeal has been stalled or blocked because the court transcript cost $10,000. Y'all gotta stop with the misinformation, and y'all have to stop believing it. If y'all have questions, y'all can definitely drop in my inbox and ask me, is this true, before you sit there and you wreak havoc for no reason. This motion came out yesterday, and they're sitting there telling y'all, so it's not the fact that they can't afford it. They can't get it because it hasn't been transcribed. The clerk record, the shit is still in the chambers. I'm about to break my damn pen. We gotta stop. And y'all, for the love of, if y'all see stuff like that, challenge these people that's putting out this misinformation. Do not be sitting there. Somebody had a call to call an action to call the district clerk's office. Y'all, they can't. Now, granted, I get it. But the only thing y'all are doing is pissing them the fuck off. And excuse my language, but that's what you're doing. On top of this case, they got several other things that they are doing. Several other things. Now, me, I still gotta call their ass to get some stuff for some of my cases. I don't want them pissed at me. I have to get my work done. And I can't get my work done if you can't give me what I'm requesting because you pissed, because you having a bad day, because people are calling you, hounding you about getting, stop it. Y'all are making it harder, not just for the court clerks, for people who actually work in the legal field that actually got to get stuff from the court. You're doing more damage than you are good. But I say all of that to say, stop believing all the misinformation out there. They can't get the transcript because it hasn't been transcribed. That means that it has to go to somebody to make sure that everything is true and correct. Then they send it to whoever, and they say, okay, if any changes need to be done, blase, blase, blase. It actually has to go on a certification form. I wish I could get my friend on here because she is a court reporter for federal and state court. She does her thug thizzle. But it's a process. But don't be bugging these people because y'all doing more harm than good. And number two, stop putting out misinformation and y'all start challenging these people. So the reason why they can't get the goddamn transcript is because it hasn't been transcribed. All right. All right. Let me see. I'm not talking about the family. I'll talk about the lawyer. Oh, I don't know what y'all got going on there. It's a damn. Oh, hell no. That's a mosquito. I hate them damn mosquitoes. Someone's biting me. All right. Now, first ground. So now what are the grounds for a new trial? This is what they're saying. I need to kill because I hate freaking mosquitoes. I don't know how he got in here. First ground for new trial. The trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceeding without the finding and alternatives required by Waller, Presley, and Strickler. So we have gone over everything that they have done. Those were all the facts. Now they're telling you the grounds. So the first one is because the trial court violated the defendant's Sixth Amendment right. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high-profile criminal trial, the court made the findings, Waller versus Georgia, requires and considered the reasonable alternatives, Presley versus Georgia, demands for contemporaneous public access. It did not. The court's order gave the general public only a 10-minute daily. What was I at? The court order gave the general public only a 10-minute daily initial admission window, left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings, and provided an overflow room, no audio feed, and no video feed for the foreseeable turned away. Y'all get this a damn mosquito in here. Them getting on my nerves. Oh. Now I don't know if this is gonna do the trick, but babe, I got me some peppermint oil. So maybe if I put some peppermint, he ain't gonna fuck with me. We're gonna see. They say mosquitoes don't like peppermint. All right. Once closure is shown, it cannot stand unless a record contains a Waller complaint. That's justification for those restrictions. The existing record contains none. Nor does the danger end with this case. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and stream it as an easy decision and stating that it had struck that balance pretty well. Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, and no live stream be treated as an adequate substitute for an open courtroom, the public trial guarantee of the First and Sixth Amendment would be hollowed out in practice. And they did that. Oh, she said that's Trolls that spread misinformation about Karmelo. That's why we just thank you. But actually, no, I done seen some black folks spread some misinformation too. So I can't just put it on them white supremacists. I cannot. I cannot. I cannot do that. Thanks for breakdown. Oh, thank you so much. Thank you, thank you, thank you. All right, let's get back into this. All right. The restrictions here amounted to a closure of the courtroom imposed without the finding the law requires. Defendants does not contend that live streaming is constitutionally required in every case. The issue is that once physical seatings was foreseeable and adequate, the court was required to consider reasonable alternatives and make Waller findings before excluding the public. Like, once again, and I keep saying this is not stuff that people are just making up. His appellate team is not making any of this up. There are codes and rules and statutes that judges have to follow, attorneys have to follow. Period. There are federal laws that you have to follow. Period. So they're breaking down and they're sitting here telling you, this is what this amendment says. This is what this law says. This is what this statute says. This is what this code says. This is where you fucked up at. It is not that hard to put two and two together at all. I for the life of me, I can't understand why some people are just oblivious as to exactly where this information. If you want, you can look up the Texas Rules of Civil Procedure, the Texas Rules of Criminal Procedure, the Texas Appellate Rules, the federal, like, you can look all of this up, but do you choose to do that? No. Because in my opinion, I think that you know that we're right and you hate to be wrong, because then you resort to the racist bigotry in people comments. And that just tells it all. All right. A, an open courtroom belongs to the people of Texas who fund and sustain it. All right. The openness of criminal trials is among the oldest and most settled features of Anglo-American justice. Baby, but y'all can see this, baby. I just love shit like this. Okay, I'm getting excited. The openness of criminal trials is among the oldest and most settled features of Anglo-American justice, aka hell, your people created these laws and now y'all don't want to follow them. Okay. The United States Supreme Court has held that the public and the press poses a right secured by the First and 14th Amendments to attend criminal trials, and that absent an overriding interest articulated in findings, a criminal trial must be open to the public. The Anglo-American justice system made these rules. But anywho's, let's go into this. They cited Richmond Newspapers Inc. versus Virginia, Globe Newspaper versus Superior Press Enterprise. See, all of those is just talking about the media, okay? A presumption of openness inheres in the very nature of a criminal trial under our system of justice. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against decisions based on secret bias or partiality. As the court observed, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which the criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings and trials in all courts shall be public. Y'all see that? Texas Code Criminal Procedure, Article 1.24. the court. So don't come in here and talk about, well, he didn't have to have open. Well, according to the criminal command, the criminal procedure, all courts shall be public. The Court of Criminal Appeals have embraced the presumption of openness recognized in Richmond newspapers, explaining more than a century ago that the Texas Constitution is but in accord with the genius and spirit of our free institutions, which is intended to guarantee publicity to the proceedings of our courts. These guarantees are not abstractions, and they are not held by accused alone. The open trial guarantees belongs as well to the citizens of Texas, in whose name the prosecution is brought, by whose taxes the courthouse and the court are sustained, and whose confidence in the administration of justice depends on their ability to see the justice done. Public attendance is the mechanism by which the community observes that the court it funds are functioning lawfully, a check on official power that the Supreme Court has repeatedly identified as the core purpose of the open trial guarantee. I don't know if y'all follow Dr. Candace Matthews. She's out of Houston, but baby, that's one issue. There's a court down there right there where loved ones can't go in that courtroom and see what's going on with their loved one's case. And baby, she went up in there. By the Texas, it states that we have a right. We have a right. I could go right now and go sit in a criminal trial if I want to. And I have done that. I've done that. I'm at Jaguar Wright. She had a hearing. I took my ass up there. And she ain't show, but I took my behind up there. Public attendance is the mechanism. Okay, I already read that. When the public is excluded from a Texas courtroom without lawful justification, that injury falls on the defendant whose Sixth Amendment right is violated and on the community whose courtroom it is. It is the defendant's injury that this motion vindicates. The community's stake underscores why the violation is neither technical nor trivial. A public trial is staged for two audiences at once. The first sits in the gallery, the citizens in whose name the case is brought, who watch to satisfy themselves that the state proves that what it claims and that the accused is not quietly condemned. The second sits on the bench and in the jury box, the judge and the jury, from whom the awareness of being watched is itself a discipline, keeping them keenly alive to a sense of their responsibility and to the importance of their functions. Kind of tell you why they have to set up, why the judge is here, you know, the court reporter is there, the bailiff is there, the jury is here. You know, it's a reason why the court is set up the way that it's set up. Blah, 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 blah. The second sits on the bench and in the jury box. Okay, I already read that. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it relieves the court of the very audience whose presence is the discipline. What the order describes as access operated in practice as material exclusion. History explains why the law guards the open courtroom so jealously. The public trial guarantee is a long-standing safeguard against secret proceedings. It has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution. What openness protects, secrecy endangers. A proceeding the public cannot watch is one in which the ordinary checks on error, overreach, and bias quietly falls away. That is the structural risk a closed courtroom creates. Whether or not anyone can later prove the harm the secrecy concealed, which is precisely why the law treats the deprivation as structural and does not put the defendant to proof of a hidden injury. B, A courtroom may be closed only rarely and only on the showing while it requires. The most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals, handed down months before this trial began. In Strickler versus State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial, where the court, citing courtroom space and generalized security concern, refused to sit a single member of the public during jury selection without first considering the reasonable alternatives to the law. You know what? I'm about to reread that again in hopes that it clicked. The most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals handed down months before this trial began. In Strickler versus State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial. So what happened? Where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during jury selection without first considering the reasonable alternatives the law requires. We already read that. You remember what they were talking about, how people were getting there from this and this time, and this person was fifth in line, and now they 25th in line, so now they can't go in. That very ruling in another case, they sat there and ordered a new trial for that simple reason. Okay? Because Stricker was designated for publication under the Texas Rule of Appellate Procedure 47.2b, it is a published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial question. And it said Fifth Court of Appeal. Wait, is Strickler? Is that Dallas? Hold up. Oh, no, that is. That's Dallas. That's Dallas right here, Strickler. So the same Court of Appeals that this case is in, that same panel back in January issued an opinion stating that that court violated the defendant's Sixth Amendment and ordered a new trial. I'm becoming more optimistic each day. Each day. I have to go pull that memorandum. Let me write that down. I'm going to pull that memorandum. The Fifth Court of Appeals that we are in right now, they issued opinion ordered earlier that year. Court Stricker. I said Stricker. Is it Striker versus State? It's one of them. 0524010991. See, I'm gonna pull that. I'm gonna pull that opinion, and I might do a video on that so y'all can see, because I want y'all to understand. I want y'all to understand how this works, how the Fifth Court of Appeals will work. Crazy thing, we can sit here and watch the Tyler. Okay, that part right there. But see, that's the thing. Collin County thinks that they are untouchable. Forget DA Craig Willis. He really thinks that he's untouchable. But this whole county, that's why they call them the lawless county. That's beautiful. That is really beautiful. And having been issued months before it was available for the trial court's review, when the court entered the amended order and closed these proceedings. The closure here was therefore not a resolution of an unsettled question. It ran headlong into a recent published decision. I'm definitely going. Let me put a star. I'm gonna pull that and I'm gonna read that. Every justification the Fifth Court rejected in Stricker is a justification the court invoked here, and that rejection was far more extreme facts. There, the court refused to seat one observer because the veneer filled the gallery. Here, the court rationed the general public to roughly 2 dozen rotating seats across every stage of a nationally watched murder trial. There, the trial court declined to split voir dire to make room, explaining, I am not going to spend 2 days picking a jury. The Fifth Court held that space and overcrowding, through legitimate concerns, must not outweigh a defendant's Sixth Amendment rights because there are readily available alternatives and that neither convenience nor judicial economy can constitute an overriding interest. Here, the record and the court's own public statements at least raise the fact issue that reasonable alternatives existed, including larger or additional courtroom space, a live audio or video feed, and the overflow accommodations the court used during jury selection and then withdrew. So y'all had the my hair's sticking out. Y'all had the accommodations and then y'all took them away. That's where y'all fucked up at. And where the Stricker court faulted the trial judge for failing to identify a specific concrete fact. Because what was your reasoning for giving alternatives but taking them away? The order here rests on the same generic recital that unrestricted access may compromise security entering without a hearing. If excluding a single member of a public from jury selection required a new trial in Stricker, then the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller findings cannot be dismissed as trivial. A second Court of Appeals reached the same result weeks later on fact materially indistinguishable from space rational invoked here. In Hernandez versus State, which is the 14th Court of Appeals in Houston, reversed a capital murder conviction. Y'all, if y'all not tuning in, I need y'all to tune in, especially for, yes, part of Wiley is in Collin County. Now, babe, have you heard about Wiley? Babe, you gotta search Wiley. Wiley actually had a few issues. My son used to play soccer in Wiley, but there has been a few instances in Wiley. I would reconsider that. Me personally, I live in Richardson. I love Richardson. Richardson is a melting pot. My kids got friends that they're diverse, and I love it here. I love it. But Wiley, no. Saxy probably. We'll talk. Okay, but going back to what I'm saying. So we already have the Fifth Court of Appeals. They ordered a new trial because the trial court didn't allow for one person to there wasn't accommodations. Okay, let's put it that way. Now we got a second Court of Appeals back in Houston in the 14th Court, and I'm going to reread this part. A second Court of Appeals reached the same result weeks later. Mind you, Stricker came out, January 2026? And so, May 19, 2026 is where they issued their opinion. In Hernandez versus State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person veneer and a lack of physical space without conducting a Waller analysis, making findings or considerable reasonable alternatives. Baby, I'm about to pull both of these 14250092 because I love presenting facts for those who state, oh, he's not going to get a new trial. Like I always tell you guys, it's not about The sentence is not about the 35 years. It is about the procedures in the trial court. That is the whole purpose of an appeal. See, when you don't understand the appeals process, you just, I guess people just make shit up out their ass and say whatever they do on Beyonce here internet. Mm-hmm. Let me see. All right. The court held that concerns about space must not outweigh a defendant's Sixth Amendment right, and admonished that trial courts are expected to know and apply this basic rule. Stryker and Hernandez are thus recent, not 10 years ago, this year, recent published Texas decisions holding that a space-based closure of jury selection entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for the court's review before this trial. So the court, aka Judge Roach, should have said, okay, well, let me make sure there hasn't been any ruling in similar cases to ensure that I do everything that I need to do on my part. And he failed to do that. Thank you, Gold Digger. Thank you, ma'am. The appeals team is really good. I hope this set a precedent for other Black law firms to get involved for future wrongfully convicted. Yeah, and what I'm telling y'all, I swear, and those my day ones. Y'all know me. I have been battling as to I love being a paralegal. I actually got into law school, but my husband at the time didn't want to move to Pennsylvania, so I'm just like, okay, fuck it. I ended up getting my MBA. Did I get my MBA first? Yeah, I got my MBA first. But I've always wanted to be a lawyer. And then, but as a paralegal, I enjoy doing the work. But now that I do the work, hell, I could just be a solo practitioner. I don't care. But over the years, I have just, even starting this channel and kind of get into things of this nature, it's just like, I can't do a lot of stuff as a paralegal than I can as an attorney. And so right now I'm really fighting a battle of whether or not I should go to law school. Like I got my loans forgiven because I have a nonprofit and all the other stuff. And it's like, damn, I don't want to rack up more debt, but it's for a greater purpose, if that makes sense. So I was like, my youngest going to 8th grade. He got 5 more years till he graduate. Law school is only 4 more years. I can do this. So y'all just pray for me. I pray for myself because I know that this is my teaching, and in the legal field is something I've always wanted to do. And I've actually worked very hard to make that come true. And my teaching, that's good. I'm where I want to be. But as far as in the legal field, I think I can do more. And if I do decide, I really want to get into criminal because I feel that there is a lack of Black women who are criminal attorneys. Not putting down the men, but I feel like we got to step our game up. Oh my gosh. Okay. Cherry Blossom, what did you say? Why couldn't they just follow the rules? Thank you, Cassandra. I'm afraid of what would happen if paralegals and journalists on the internet did nothing. No, you are so correct. You are so correct. And that's why I started I didn't start, y'all know me. I don't care if I have 2 people on here. I want factual information going out to the masses. That's what I want. And I was like, why not put my expertise on a platform when I can? And that's why I'm here. That is why I'm here. Wait, I can't. No. So me I'm just a paralegal. So I can't represent nobody. I cannot represent anybody. Now, Texas Supreme Court has passed where paralegals, if they take a certification, a test or certification, whatever the case may be, we can actually represent like individuals in family law. I forgot, was it estate planning? So it's like certain areas, but a paralegal would not be able to represent nobody. We cannot do that. And attorneys are even fighting for to represent somebody in a family law case. I'm just like I draft all of the paperwork. The only thing you do is go to court, say a couple of words, sign a document, and that's it. I draft all the damn paperwork. Cause what? Now, granted, they may do motions for summary judgments and motions and hell, I draft the motions of limine. But that's neither here nor there. So no, to answer your question, no, paralegals can't represent. All we do is draft. All we do is draft. Oh, I don't know if y'all can hear. I think people can hear me. Yeah, just go out and come back in, cause we here. Oh, well, somebody tell her in the chat that we here. I don't know what's going on. All right, so we already have Stricker versus the state, and who is this? Hernandez, and they versus the state, and the Court of Appeals said that in both cases, because the defendant's 6 minute right was violated because they didn't have space to put people in the public in to actually view the trial. They said, okay, it needs to be a new trial. That is freaking dope. Now, Cherry Blossom, girl, them people is fighting. It went through the Supreme Court, but you still got to take a certification, but it hasn't been like really set in stone. Oh, you know what? Yes, perfect blackness. Yep. I think I might do that. That means I would have to stay away from YouTube because my friend, I just went to her graduation in May. She just graduated from UNT College of Law. And she's like, Cassandra, because she's the main one. Cassandra, you need to go law school. I'm just like, I already got 3 degrees. I don't want another one. But we'll see. Y'all just pray for me. That's all I can say. All right, so we got those 2 cases. The Court of Criminal Appeals. Now in Texas, after so there are 14. Yeah, there's 14 Court of Appeals. If for any reason it doesn't work out in that block, and I showed y'all the diagram. So it's like the trial courts, the Court of Appeals, and you have the Texas Criminal Court of Appeals, and then you got one for civil. So for criminal, so if it doesn't work out in the Court of Appeals, then it will go to the Court of Criminal Appeals. And it says the Court of Criminal Appeals has likewise reversed on a narrower version of this problem. In Stedman versus State, the court reversed the conviction and ordered a new trial because a trial judge excluded the defendant's family from a voir dire out of a generalized concern about space without articulating a specific threat and without considering reasonable alternatives. This case in Stedman magnified at every dimension. The court excluded not one family, but the general public, not from voir dire alone, from every stage of the trial, on finding no less generic that unrestricted access may compromise security, jury privacy, in a fair trial without a hearing. And after using, then abandoning the very kind of overflow alternative Stedman faults courts for failing to consider. If barring a single family from jury selection was structural error demanding a new trial, excluding members of the public from substantial portions of jury selection, testimony, and punishment is so a 40, yeah, they using some Latin terms. Yeah, baby, I don't know how to pronounce that. I ain't gonna try. But what they're saying is, if because you barred a family, hold on, my nightlight about to turn on. Because you barred a family, hold on, let me turn off this nightlight. Oh, it's 10 o'clock. What time? Damn, we've been in off almost. We got to wrap this up. So in other words, you can't just say, okay, you can't put an overflow in place or alternatives in place and then take it away for no legitimate reason. You can't do that. And they have provided us with 2 Court of Appeal cases that ordered a new trial and a Supreme Court case that did the same thing. The Sixth Amendment to the United States Constitution guarantees the accused in a criminal persecution the right to a public trial, a guarantee applicable to the states through a 14th Amendment. Henry Oliver, that came from that site. The Texas Constitution independently secures the same right, providing that the accused shall have a speedy public trial. The proceedings and trials in all courts shall be public. That is part of the Texas Code of Criminal Procedure, Article 1.24. The right to a public trial is not confined to the presentation of evidence. It extends to jury selection. Presley versus Georgia. Before a trial court may exclude the public from any part of a criminal proceeding, it must satisfy the 4-part test of Waller versus Georgia. And this is where the Waller findings come in at. 1, the party seeking to limit access must advance an overriding interest that is likely to be prejudiced. 2, any limitation must be no broader than necessary to protect that interest. 3, the trial court must consider reasonable alternatives to closing the proceeding. And 4, the trial court must make findings adequate to support the limitation. The Court of Criminal Appeals has adopted and applied this test in Stedman versus State. The trial court bears the burden of considering reasonable alternatives. The balance of interest must be struck with special care, and findings by the trial court are linchpin of the Waller's test. 41, the right of public access applies with particular force to the selection of the jury. The Supreme Court has held that the guarantee of open criminal proceedings reaches the voir dire of prospective jurors because the selection of jurors has presumptively been a public process with exceptions only for good cause shown. Open jury selection was the settled practice in America when the Constitution was adopted, and the court emphasized that proceedings conducted in secret frustrate the very public interest that open selection exists to serve. Closure of jury selection is therefore permissible only on the same showing of an overriding interest, narrowing, tailoring, and specific finding that Waller and Press Enterprise require. The order's restriction nonetheless applied to jury selection along with every other phase of the trial, conducted behind the same closed doors and unsupported by any such findings. Like, come on. Your founding fathers came up with these rules. Y'all don't follow them. Y'all are so patriotic. Y'all are so American. You can't even follow the rules that your founding fathers set. 10 minutes a day did not keep this courtroom open to the public. A reviewing court first characterizes the restriction. A full closure is tested under all 4 Waller factors. A partial closure is tested under the same factors, with the first requiring a substantial rather than an overriding reason, and only a truly trivial or de minimis restriction leaves the public trial right, unimplicated. The court's amended order regulating trial proceedings, media access, security, and courtroom decorum, which is attached as Exhibit 1, was not a trivial restriction. It provided in pertinent part. The courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. for members of the media and 8:40 a.m. for designated family members and at 8:50 for members of the general public. So they gave you a schedule as to what time the courtroom will be open. No more than 9 members of the media shall be permitted in the courtroom at any one time. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 a.m. and individuals arriving after that time shall not be admitted until recess. Once admitted into the courtroom, no person shall leave or re-enter during proceedings except during a recess. By its terms, the order's only affirmative window for the general public to enter was a 10 minutes between 8:50 a.m. and 9 a.m. Think about all these people, and you're only giving them a 10-minute window. The remainder of the provisions spoke in terms of exclusion. The doors shall promptly close at 9 a.m. Individuals arriving afterward shall not be admitted until recess, and no person shall leave or re-enter during proceedings except during a recess. The order capped media presence at 9 persons, made seating space available, and contained no provision for admitting members of the public as seats become open during the proceedings, nor did it furnish any overflow room, audio feed, or video feed for the public unable to be seated. So after you say, okay, the doors is going to promptly close at 9, if you arrive after 9, this is where you would need to go to the overflow room and have procedures for that. You didn't have that. By its terms, the amended order governed all aspects of the trial proceeding, and it remained in effect and was applied throughout. The restrictions operated continuously and were not confined to any discrete portion of the case. They governed the jury selection, the guilty-innocent phase, and the punishment phase alike. The closure was therefore pervasive rather than incidental, depriving the public of access to every stage of the proceeding at the order applied. The cumulative and practical effect of the provisions was to exclude members of the public from the proceeding at every stage at which the order applied, including jury selection, the guilt-innocent phase, and the punishment phase, which constitutes a closure subject to Waller. The defendant bears the initial burden to show that the trial was closed to the public, but the burden is carried only on the totality of the evidence, and the inquiry does not turn on whether the defendant can show that any particular person was actually excluded. The reviewing court instead asked whether the trial court fulfilled its obligation to take every reasonable measure to accommodate the public attendance. So that is what we're asking. We're asking, did the trial court, did Judge John Roach Court fulfill every last obligation to take reasonable measures to ensure that everybody that was coming in to, sit in trial, were they accommodated? Here, the cumulative effect of the 9 media cap, the 10-minute public entry window, space available seating, and the no re-entry rule, and the absence of any overflow or live stream establishes that members of the public were excluded. And the defendant has carried his burden to show that the proceedings were closed. These facts are further established by the accompanying declarations of members of the public who sought to attend the trial and were denied entry to the courtroom. Now, there are declarations from each of the individuals. Remember, there was somebody that came from North Carolina who came in. There was a few people that were there that were actually turned away with no alternative as to going to an overflow room. That's crazy. That is crazy. Now we ain't gonna go over. There's a lot of whatchamacallits. I'll probably read them probably tomorrow so y'all can get an understanding. But here, what they did is they took the true statements or each statement account from those individuals who were turned away. They made them do an affidavit, and that is their support to this. That so their statements is saying that I arrived at this time, this is what was said to me, so on and so forth. Because by them citing the Stricker versus State, Hernandez versus State, in that Stearman or Stepman case from the Court of Appeals, Texas Court of Appeals, that helps their case. Like, you have these members of the public that were denied access to the courtroom during this time. Now, right there, looking at what even our own Fifth Court of Appeals, the court that this case is in, seeing that they have already not allowed, they pretty much said that a trial court, you violated his Sixth Amendment right, or his or her, I don't know, defendant, and a new trial needs to be had. I don't know. I need to look and see, because I'm from South Carolina, so that'd be cool if they were from. But I don't know. I know his dad's side is from Louisiana, or his dad graduated from LSU. I think so. I have to look at that. Those declarations, excluded by members of the public who came from across the country to attend, established the closure concretely and consistently, and no witness observed any disturbance or security incident that would explain it. Jacqueline Young traveled from North Carolina. On the first day of testimony, she found a line of roughly 80 to 100 people and watched as about 27 were admitted, with no overflow room provided for the remainder. Tara Allen flew from Arizona and observed jury selection from an auxiliary viewing location she knew as the Oval Room on June 1st and the 3rd. And on the 4th, she was told that accommodations had been eliminated and she was excluded from the courtroom on both June 4th and 5th. Bridget Smith attended on the 1st, 4th, 5th, and 6th and confirms that public seating was capped at roughly 27 seats, that admission was divided into two lines, one for the media list and one for everyone else, and that the outside viewing location used during jury selection was eliminated once testimony begun. Tamisha Carter arrived before dawn and, though identified as number 7 on the early arrival list, was removed from the June 5th line and lost the morning proceedings because only about 27 public seats were available. Kiara West, a member of the general public with no media affiliation, was denied entry on June 1st on a purported jury member-only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. And Tony, I don't want to butcher the last name, the defendant's own grandmother, attests that the family access was capped at 8 seats in total. Remind you, the prosecution family, the family had 15 seats. The defendant's family supposed to have 15 seats, but then they dropped it down to 8 seats in total. So that the defendant's grandfather and aunts were excluded from the trial altogether, and that even those admitted were required to register a day in advance and was warned that a visible facial expression could result in removal. Y'all give me a second. He must be bored. Let's see. That's sad. One member of the public attended the trial nearly in its entirety and provides a day-to-day account that corroborates each of the features from inside. Nakia Washington traveled from Cincinnati, Ohio, and was present at the courthouse on June 1st, 3rd, 4th, 5th, 6th, 8th, and 9th, 2026. During jury selection, the court used an auxiliary viewing courtroom known as the memorial room that seated roughly 60 members of the public and carried a live video and audio feed of the proceedings. On June 4th, the first day of testimony, the public was informed only after arriving that the overflow room would not be available for the remainder of the trial, and access was thereafter confined to approximately 27 seats inside the courtroom with no overflow room, audio feed, or video feed of any kind. Access each day was governed not by the order's admission time, but by pre-dawn line that formed as early as 4 a.m., 4 to 4:30 a.m., was counted off in groups of 27 and was inconsistent and at times chaotic. And although Miss Washington ultimately gained entry on each day she attended, she was excluded from the morning proceedings on both June 4th and 5th, admitted only in the early afternoon after substantial portions of the day had already passed, so that even in attending, members of the public was denied access to significant parts of the trial. She observed no disturbance or no disruptive conduct inside the courthouse and would justify excluding the public, or that would justify excluding the public. The only altercation she witnessed occurred outside in the line and arose from a very manner in which the court administered access. This right here, y'all, those are receipts. They already told y'all the cases that the appeals court that said, okay, there's a new trial because y'all did not include members of the public. And we have several people that weren't included. So what y'all think? Do y'all think that a new trial is going to be granted after hearing what you just heard? If you believe that, definitely put a 1 in the chat. If you are on Facebook, you better come over here on the YouTube. This case is not controlled by the decisions on which the state may rely. In Dixon versus State, the Court of Criminal Appeals held that a public trial right is forfeitable and that a full courtroom standing alone does not violate the guarantee because the right does not require the court to seat every person who wishes to attend. Defendant does not contend otherwise. The violation here is not the courtroom filled. It is the court's adopted in advance and without case-specific findings, a recurring access regimen that limited the general public to a 10-minute daily entry window and roughly 24 seats, barred meaningful mid-proceeding access, and furnished no contemporaneous alternatives for the foreseeable excluded. Nor would Dixon's disposition aid the state. There, the claim exclusion was a portion of a singles-day closing argument provided by one witness against an otherwise silent record, and the trial court resolved the factual dispute only after a contested hearing. Here, the closure spans the testimonial phases of the trial and is established by 7 mutually corroborating sworn accounts by the written admission of the court's own appointed officer that there is no overflow room, by the court's own televised confirmation of seating figures, and by the undisputed elimination of an accommodation the court had itself been providing, and no findings of any kind exist to the difference could attach. So what they are pretty much saying is not only do they have several people who submitted affidavits stating that this happened to them, the own appointed, I don't know if it was a public information officer. He even stated in an email that I believe came from a Gmail that there was no overflow. There was no overflow room. That's where you fucked up at. So in addition to the affidavits, you have this man who sent it from his personal Gmail that says there is no overflow room. By law, you have to make accommodations. By law, you have to have an alternative as to what you're going to do with the people who cannot be in the courtroom. What alternatives do you have for those members of the public and the media? Well, obviously the media gonna get in, but what, like, so the people that are left over that can't get in the courtroom, what accommodations do you have? What other alternatives do you have so that they can hear, they can see, they can witness this trial that is supposed to be open by the public? And then your boy went on national TV and said what he said in regards to the courtroom. So that right there, I think that's sufficient documentation to support this motion for a new trial. And then it says, nor is this Williams versus State, in which the Court of Criminal Appeals, the highest court, treated the brief exclusion of a single family member during one witness testimony, mitigated by a live video feed to a neighboring courtroom, as a trivial de minimis closure that did not implicate the Sixth Amendment. The restriction here was the opposite of the trivial. It was not a single brief exclusion tied to one witness. It was not accompanied by any live feed. It was not supported by witness-specific findings. It was a trial-wide access regimen applied across jury selection, the guilt-innocent phase, and the punishment phase. Under Williams' own framework, a closure of that scope is tested under Waller, not excused as de minimis. Indeed, the Williams court took pains to cabin its holding. It characterized the triviality doctrine as an exceedingly narrow exception to Waller, reaffirmed that Waller remains the primary framework for analyzing courtroom closures under the Sixth Amendment, and admonished that the doctrine should be employed sparingly and only in the narrowest circumstances. The court expressly declined to mark the doctrine's outer boundaries, leaving that task to future cases with different facts. A standing, trial-wide access regimen spanning jury selection, the guilt-innocent phase, and the punishment phase, because remember, those went all through those days, is not the rare circumstances Williams contemplated. It is the ordinary closure for which Waller supplies the governing test. And this Court of Appeals has already applied that principle to reject the very triviality argument the state may advance here. In Strickler, it declined to treat the exclusion of the public from jury selection as trivial, holding that the values sought to be implicated by the Sixth Amendment are violated when the public is excluded from jury selection. Thank you. This appeal by Mello's team seems to actually be written to speak to the Federal Appeals Court. It's very technical, constitutionally, very smart. You got it. He has the best team ever. Judge Roach, y'all kill me with the dang roaches. Yeah, this does not look like it's good for his way out at all. And y'all, if y'all just coming in, welcome to my channel. Hit that like button, share, subscribe. If you're on True Crime Talk with Favorite Paralegal, definitely do the same. If you're on Facebook, definitely like and share. And you can come over to Facebook. You can definitely come on. All right, y'all. I'm trying to wrap this up. I want to finish this today. All right, so the defendant. Hold on, let me take, because my child getting on my nerves. Boy, are you deaf? God. All right, so defendant need not prove that every seat was empty or that every member of the public was excluded. At minimum, the access regimen was a partial closure. Members of the public were repeatedly excluded from substantial portions of the proceedings, while no continuing overflow audio or video access was provided. Under Williams and Stricker, even a partial closure may satisfy the remaining Waller factors, narrow tailoring the consideration of reasonable alternatives and adequate findings. Those factors are absent here. These decisions do not create a mechanical rule that a live feed is always required or always sufficient. They make a narrow point. When seating limits predictability excludes the public, the trial court must consider practical alternatives, reserve public seating, a larger courtroom, staggered admission, an overflow room, or an audio or video feed, and must make findings explaining why any rejected alternative is inadequate. Here, the court used an overflow alternative during jury selection and then withdrew it when the testimony began. Case Waller versus Georgia. Overflow room or live remote feed available? No. The entire suppression hearing was closed. No alternative offered. Outcome: the appeals court stated that the closure was unjustified. New suppression hearing was ordered. In Stedman versus State, this was Texas Criminal Appeals Court. This is the highest court in Texas. Was an overflow room or live remote feed available? No. What happened? The family barred from the voir dire for a lack of room, alternative not considered. So what was the outcome of that? They ruled that it was a structural error, the conviction was reversed, and a new trial was ordered. Oh, baby. Lilly versus State. This is, again, in the Texas highest court. So, no alternatives. The trial was conducted in a restricted access setting. The outcome: the appeals court ruled that it was a structural error. A new trial was set. Presley versus Georgia, 2010. And so what Lilly, Waller, Lilly was 2012. Yeah. Same thing. Reserved rows, overflow not considered. What happened? They reversed it. Trial court must consider reasonable alternatives. Williams versus State. So yes, they actually did have a live feeding to a neighboring courtroom. But guess what? It was a trivial closure. It was a trivial closure, no violation. Same with Zorns versus Boolin. They actually offered a remote viewing from a observation room. Trivial closure, no violation. Now, in this particular case, provided during jury selection, then withdrawn for the testimony, no feed thereafter. This falls under Waller, Stedman, and Lilly. So you see what happened in there? New suppression hearing, conviction reversed, new trial ordered, new trial ordered. Yes, belt to butt. That's what it is. So here are actual cases that are either in the that were in the appeals court or Texas highest court, the Texas Criminal Appeals Court. Either a new trial was ordered or a suppression hearing was ordered, except for Waller versus Georgia. That was in Georgia. But still, do you see these cases? So based off of what happened, because they failed to actually provide alternative means, that right there, you can get a new trial. Based off of the affidavits that were submitted, based off of what your judge said, and based off of what your boy sent in the email from his Gmail account. I mean, you don't have to be on either side. It's understanding and comprehending how the law is applied. Going back, I was a social studies teacher. Okay? The legislative branch makes the laws. The executive branch executes the laws. The judicial branch applies the laws. Here we have cases. The law says one thing. Because you did not follow the law, therefore, we're going to undo what you did. So that's why I keep telling people, it is not about the sentence itself. It is about the procedures in the courtroom. That is where they fucked up at. This case sits on the wrong side of that line, and uniquely so. The court did not merely fail to provide an alternative, it provided one during jury selection, a live feed to an overflow room, and then switched it off for testimonial phases, the most consequential part of the trial. A court has shown it can pipe the proceedings to an overflow room, then darkens the feed when the witnesses take the stand, has not taken every reasonable measure to accommodate public attendance. So by you saying, okay, we're gonna do this, and then you take it away, it showed that you had not availability, but it showed that you can do this. It showed that you can give alternative measures. But his statement was that he wanted to protect the witnesses and the jury and all this other stuff. That's why he did not allow for, the cameras and certain people to be in the room, so on and so forth. But what does that have to do with anything? Critically, the closure was imposed by the court on its own motion. No party moved to close the courtroom or to restrict public access. The court entered the amended order sua sponte, conducted no evidentiary hearing, and received no evidence in support of any interest offered to justify the restrictions. Defendant was not afforded a pre-order hearing or an opportunity to be heard before the access regimen was imposed. And the written order did not disclose the facts that made the closure apparent in operation: the actual allocation of public and family seats, the dense family limitation, the withdrawal of the overflow room when testimony began, the denial or alternate access, or the off-road administration of the public line. In actual operation, public access was even more restricted than the order text provided. The deficiencies in the order's text were compounded by the way the access regimen operated in practice. Because a closure is assessed on the totality of evidence, the actual operation of the regimen is properly before the court. The affidavit of Thelma Anderson, a member of the public who repeatedly sought to attend the trial, establishes that the regimen operated more restrictively than its text provided, and that a reasonable alternative was not merely overlooked, but affirmatively withdrawn. So they're not saying that it wasn't there, they're just saying that it was there and y'all just took it away. These facts compound the deficiencies apparent on the order's face. They do not supplement them. Consistent with Carmen and Lily, the closure is established on the totality of the evidence, and the defendant need not show any particular member of the public was excluded. Most significantly, the court demonstrated that an overflow viewing room was both available and workable, and then took it away. During jury selection on June 3rd, 2026, the court provided an auxiliary viewing location outside the courtroom where members of the public who could not be seated inside could still observe the proceedings. The court did not merely provide this accommodation. It announced it in writing before trial. On May 29, 2026, the court appointed public information officer advised the public that the media and general public will have an opportunity to watch a live feed of the jury selection process from the ceremonial courtroom. The television monitors and audio provided, and that once testimony begins, the proceedings will take place in the 296th District Courtroom following the same procedures. On June 4th, 2026, the first day of testimony, the court eliminated that accommodation and confined public access to the seats inside the courtroom, with no overflow room, no audio feed, and no video feed of any kind. The significance is twofold. First, the court's own use of an overflow room during voir dire proves that a reasonable and readily available alternative to exclusion existed, the very kind of alternative Presley required the court to consider. Second, the court did not merely fail to consider that alternative. It adopted the alternative and then withdrew it for the guilt, innocence, and punishment phases. Without findings and without explanation, narrowing public access precisely as the most consequential Damn. Consequential testimony began. The reason a deputy gave members of the public for refusing overflow that the trial courtroom was the only room without video conferencing Zoom capability does not withstand scrutiny. Defendant expects to establish at the hearing through courtroom administration and information technology witnesses that the courthouse space and the technology were available to provide continued overflow or audio-video access. At minimum, the court's public statements thanking the other judges of the county and the county's information technology and the facilities department for their flexibility in meeting the demands of the trial raised a fact issue that the court was required to explore before withdrawing overflow access. So you're going to thank the information technology and facilities department for what? Because if they were doing their jobs, then the members of the public would have been in the overflow room, right? So that didn't make sense, but I'm glad that they brought that up. The court had, moreover, already deployed an overflow room with live audio feed during voir dire, establishing that the space, the equipment, and the personnel to provide it existed, and acknowledged that an audio stream of the proceedings were feasible. So they had everything, they just took it away. The order only affirmative public entry window, the 10 minutes between 8:50 and 9 a.m., proved illusory in operation. In practice, the limited public seats were claimed by a line that began forming in pre-dawn hours, often between 4 a.m. to 5 p.m. Admission turned not on the entry time the order specified, but on how early a member of the public was willing to arrive and wait. A member of the public who appeared at 8:50 a.m., the time the order designates the public entry, had, as a practical matter, no realistic opportunity to be seated. The narrow window the order provided on paper was therefore narrowed still in operation, and for many members of the public, it was no window at all. Like, people was there way before that time, number 5, number 7 in line. Next thing you know, they're like the 35th, 50th person. The admission process the order set in motion operated without transparency and consistency. The order prescribed no method for allocating its limited public seats. In practice, admission was governed by an informal line in which some individuals were permitted to move ahead of others who had already waited for hours, so that a member of the public who arrived early and secured a place near the front of the line could nonetheless be displaced to a position well beyond the number of available seats. And although the order barred re-entry once proceedings began and made no provision for admitting waiting members of the public as seats open, seats did become available during the trial day as observers came and went. Yet members of the public who had waited outside were admitted, if at all, only hours later after substantial portions of the proceeding had already passed. Nor does the order provision for admission at a recess cure the exclusion. Admission at recess after the morning's testimony had been taken is exclusion from that testimony, and unlike the brief, single witness exclusion in Williams, mitigated by a contemporaneous live feed, the exclusions here were mitigated by no feed at all. The operation of the order thus produced the precise harm its text foretold. Members of the public excluded from significant portions of the trial for no contemporary means of access. This here is wild. Finally, the mechanisms by which the court administered and defended these restrictions operated off the record. A member of the public's request for an alternative viewing location could not be filed through the county's electronic system for a criminal case and was instead routed by email to a public information officer designated by the court, who reviewed and denied the request outside any judicial proceedings. No hearing was held, no evidence was taken, no order subject to appellate review was entered. At the same time, the member of the public who observed these proceedings describes no disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions proposed. Like, it'd be different if you say, okay, yeah, I closed it because people fighting outside in the hallway and all this, but none of that happened. Why did you take it away? None of that happened. The as applied operation of that order thus confirms both halves of the defect. The closure was more severe in practice than the order's text, and the generic speculative findings offered to justify it are contradicted by the conditions the public actually encountered. These conditions can be stated with precision because they recur across the sworn accounts of the members of the public who tried to attend, including the affidavit of Thelma Anderson and the accompanying declarations, and the court appointed public information officer's own email. The minute order addressed entry times, a 9-person media gap, space available seating, and reentry. It did not address and it did not authorize the following features of closure that govern access to the trial and practice. Now, I do want y'all to understand this. This is just a motion for a new trial, okay? If you're thinking about why we're not talking about the jury, that's something that's for the appeals court, okay? Right now, we have to look at errors that happen in the trial court as far as procedures, and that is what they're introducing here in these motions. So let's see. A cap of roughly 27 seats for the general public, a number the order never stated. So in that order, it never stated how many seats were available to the public. B, an off-the-record allocation of the courtrooms approximately 70 seats, 15 to each side's family, 9 to the media, and the balance to court staff, leaving only about 24 seats for the general public. C, the provision of an auxiliary overflow viewing room during jury selection on June 3rd, 2026, and its elimination on June 4th as testimony began, with no overflow room, audio feed, or video feed of any kind thereafter. D, admission governed not by the order's 8:50 a.m. entry window, but by a line that formed in the pre-dawn hours, often between 4 and 5 a.m., so that the arrival time, rather than the order scheduled, controlled who was admitted. E, the absence of any method of allocating the limited seats, producing an inconsistent and non-transparent line in which some persons were permitted to move ahead of others who have waited for hours, displacing members of the public who had arrived early to positions well beyond the available seats. The administration of public admission and the denial of access by a court-appointed public information officer and county staff who described the process in the collective first person, we choose, we invited, we had no choice, rather than by the court in open court and on record. A standardless media determination that permitted self-designated media to consume the public limited access. Through routing of requests for the alternative viewing location by email to public information officer, because the county's electronic filing system provided no category for criminal courtroom access requests, and the denial of those requests outside any judicial proceedings, leaving no hearing, no evidence, and no order subject to review. An initial prohibition on bringing notepads or pens into the courtroom, later modified a restriction on public observation found nowhere in the... You tell them they couldn't even bring notepads or pens in the courtroom? That's wild. The physical removing or turning away of individual members of the public, including the removal of a member of the public for the expressive content of her clothing, and the denial of restroom access to her minor son. So you telling me you can't let that baby go to the bathroom? Oh, I didn't even see it. Oh, I'm about to say. Yeah, if you're on Facebook and you watching and you got a problem, baby, I already told y'all what y'all can do. Y'all can definitely just scroll. Y'all can just scroll. A limit of 8 seats total for the defendant's own family, which excluded the defendant's grandfather and aunts from his trial. Because remind you, each side is supposed to have 15, but they only gave them 8. Partial access, even those eventually admitted, who in some instances were seated only in mid-afternoon after substantial portions of the day proceedings had already passed. So that's crazy. All right, let's go on. The order fails the Waller test at every step. The first Waller factor was never satisfied by anyone. That factor requires the party seeking the close of the close. Wait, the party seeking to close the hearing to advance an overriding interest that is likely to be prejudiced. Waller, oh, I'm not even going to read that part. Here, no party sought closure, no interest was advanced by any proponent, and because the court took no evidence, to be likely, uh, no interest was shown to be likely to be prejudiced. The court's generic recitals cannot supply that showing, and a court may not relieve itself of the burden of acting on its own motion. To the contrary, in Presley versus Georgia, the trial court excluded the public from voir dire on its own motion, and the Supreme Court reversed precisely because trial court must satisfy Waller and must consider reasonable alternatives even when the parties do not propose them. All right. Um, the remaining Waller factors failed as well. The restrictions were broader than necessary: a fixed numeric cap on attendance, a 10-minute public entry window, and the category absence of an overflow accommodation swept more broadly than required to protect any interest the court identified. And the record does not reflect that the court reasonable considered any reasonable alternative: an overflow room with a closed circuit audio or video feed, a larger courtroom, or staggered or reserved public seating, as Presley required it to do even on its own motion. The order's finding cannot bear the weight the Sixth Amendment places on them. The court did recite findings that the case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, jury privacy, and the defendant's right to a fair trial. But findings of this kind are legally insufficient. Hold on. This guy. I'm about to get put out my house, all that fucking yelling. Okay. All right. Okay, so let's see. Where did that boy, he gets on my nerves. All right. So they identify only generalized categories of concern, not the specific concrete facts or articulated threat that Waller and Presley require. And the word may confirms that the court identified a speculative possibility rather than demonstrated risk. The Court of Appeals rejected material similar findings in Stedman, where even detailed findings of heightened security concerns and potential jury discomfort were held insufficient because they were generic and identified no specific threat or incident. Findings specific enough that a reviewing court can determine whether the closure order was properly entered are the linchpin of Waller test, and the generic findings will necessarily invalidate a closure. These findings are not only generic, they are unsupported because the court received no evidence. The court held no evidentiary hearing on the restrictions, took no testimony, and admitted no exhibits concerning courtroom capacity, security, jury privacy, and the risk of prejudice. Findings on those subjects made without any evidentiary basis rest necessarily on either the court's own assumptions or on information outside the record, neither of which can satisfy the burden to justify a closure or support findings the defendant had no opportunity to contest. That distinction governs review. An appellate court defers to a trial court's findings of fact only insofar as they supported by record, and finding without evidentiary support receive no deference. Let's see. Nor may the deficiency be cured after the fact by post hoc assertions. Disclosure stands or falls on the finding of the court articulated when it acted. And the order's own recital that it affords reasonable public access consistent with constitutional requirements cannot be reconciled with its operative terms, a 10-minute entry window, no overflow, and no live stream, which demonstrates the opposite. Man, when I tell y'all they is going in, this is like above my pay grade. Y'all laughing at me, yeah. Baby, I'm so ready for August to come because the screen is, it's my oldest. He's like a computer gamer. I can't. I was like, you get an apartment, you about to get kicked out your apartment. And if you get kicked out your dorm, you ain't coming here. Absolutely not. The court's post-trial interviews. Oh, okay. All right. let me take a sip of water. I see what you're saying. That makes sense. By speaking over the heads of the state appeals court to the Fed court, it forces the state court to be extra creative with denying Melo's appeal. But see, that's the thing though, because this right here is addressed to the trial court. This is so the regional judge is looking at this. So this is not in the Fifth Court of Appeals just yet. If this does not work out, so let's say that this motion gets denied because they have to rule on it within 75 days of June 9th. If this gets denied, then that's when the appeal, I don't want to say kick in, but that's when that process will start rolling, even though it is rolling. And then we have to wait for the brief to see exactly, okay, if they overturn it, then, that's a good thing. But the part is we're trying to do it now versus having to wait for the appellate, court to say, okay, we're going to go ahead and do a new trial, if that makes sense. The court's post-trial interview supplies no cure for these deficiencies. There, the court suggested that the presence of minor witnesses justified limiting public access. That rationale appears nowhere in the order's contemporaneous findings, and a closure cannot be rehabilitated by a justification offered only after the fact. The adequacy of a closure is measured by the findings the court articulated at the time, which must be specific enough that a reviewing court can determine whether the closure order was properly entered. The rationale fails on its own terms in any event. The Supreme Court has squarely held that even the compelling interest in protecting minor victims of sexual offenses are a more sensitive concern than mere presence of minor witnesses does not justify a rule of mandatory closure. Protection of a minor must instead rest on a case-by-case determination supported by particularized findings that exclusion is necessary to a specific witness. So what they're saying here is because, Judge John Roach said that the reason why, parts of the trial phase was, I guess, why he didn't allow cameras, whatever the case may be, his reasoning was because he was just trying to protect the minors. But you have to have a valid reason. What are you protecting them from? You have to have some type of, reason. So a generalized concern for minor witnesses could therefore support at most a narrow measure addressed to particular testimony, not a fixed seating cap, the elimination of overflow, and the denial of any live stream across the entire trial. Texas law confirms the point. Even in juvenile proceedings in which a child stands accused and faces adjudication of delinquent conduct, the court shall open hearings to the public unless the court, for good cause shown, determine that the public should be excluded. And only for a child under the age of 14 must the court close the hearing, and then only unless the court finds that the interest of the child or interest of the public would be better served by opening the hearing to the public. If Texas keeps open even the proceedings in which a minor is the respondent, the presence of minor witnesses cannot warrant closing this adult criminal trial to the public as a whole. Because if I'm not mistaken, these were high school witnesses. So the youngest age would have been 15. Yeah, because my child is 13, going to be 14. Yeah, would have been 15, 15, 16, 17, 18. Sounds about right. So I don't know. Gomes, Sadie, girl, that's why you where you at. Girl, just go ahead and click on them three dots and put not interested and go on about your life. Girl, so you shut up. Cause I'm not the one nor the two. And I will find you. Finally, the order applied the wrong constitutional standard. It characterizes the restrictions as reasonable time, place, and manner restrictions. The standard that governs the regulation of speech in a public forum, that is not the standard for excluding the public from a criminal trial. Reasonable measures that merely administer the courtroom may be permissible, but the provisions that exclude the public, the 10-minute window, space available seating behind the media cap, the no reentry rule, and the absence of any overflow effect the closure governed by Waller and Press Enterprise, not by a more lenient time, place, manner test. By treating an access closure as a time, place, manner regulation, the court applied a less demanding standard and bypassed the findings Waller requires. The order's reliance on Shepard versus Maxwell does not assist. Shepard's concerns a court's duty to control prejudicial publicity and press conduct to protect a fair trial. It does not authorize excluding the public from the courtroom. A standing order is not substitute for an open courtroom, and every reasonable alternative was ignored. Boy. The form of the court's actions independently offered the public trial guarantee. The restrictions were imposed not by case-specific evidence-based findings developed at a hearing, but by a preemptive written standing order, an amended order ruling regulating trial proceedings adopted in advance to govern all aspects of the trial proceedings. The Office of Court Administration and published guidance grounded in Waller and its Texas progeny, has explained that no standing order or global rule for closure of specific categories of hearing may be preemptively issued by a court without running afoul of the requirement to provide the public with access to court proceedings, because the court must instead consider all reasonable alternatives to closing the proceeding and making findings in open court on the record adequate to support the closure, weighing to the totality of the circumstances. So pretty much, and that's the thing, that's probably why that transcript has not been transcribed yet, because there is a lot of things that should not have been done or wasn't done, and you're going to clearly see that on the transcript. So even with the seating situation, that's something that should have been before the court and documented via the court reporter. But it was done outside of that. This is crazy. This is crazy. The trial court is obligated to take every reasonable measure to accommodate public attendance at criminal trials, and the burden of doing so rests on the court itself. Texas courts have a proven, readily available means of discharging that burden when in-person seating is limited. Real-time public access by audio and video live stream. During the COVID-19, When shelter-in-place orders made attending a hearing in person a punishable offense, the emergency orders of the Supreme Court of Texas required that proceedings continue with reasonable notice and access to participants in the public, and the courts throughout the state discharged that obligation by live streaming proceedings to the public. And when COVID happened, I think that right there set a precedence for everything. We are able to, we don't have to leave. Like now when we schedule depositions or we do mediations, we don't leave, we don't have, I ain't even got to go to the office. I don't have to go to not near attorney's office. I could sit at home. The person that's being deposed can be in the comfort of their own home. During mediation, people can be in the comfort of their own home or even their own office, and they can literally do it via Zoom. So you're telling me that you didn't have a courtroom set up in that big behind courthouse in Collin County for people to go and actually listen and see the court and the proceedings in its entirety on each day? Let's see. If a declared statewide disaster did not excluding the public, but instead required courts to bring the public in by other reasonable means, then the comparatively ordinary demands of public interest in courtroom security cannot justify excluding members of the public here while offering no alternative at all. The court providing no overflow room, no audio feed, no video live stream, and the record does not reflect that it considered any of them. I don't even know what it shows on here because it doesn't show. So whatever it is, thank you. Okay. The alternative. These alternatives are neither novel nor untested. Across the country and in Texas, courts confronting public interest as intense as this case go far greater, have kept their proceedings open by ordinary means rather than closing them. Look at the Tyler Robinson case, for example. We saw it on TV. Members of the public are able to attend. Members of the media are able to attend. Tomorrow is going to be day 4 of the Tyler Robinson case. And that's not even the litigation phase. That's pretrial. I mean, not pretrial, that's preliminary hearing. I mean, it is the litigation phase, but it's very early and we get to see it on TV. State courts may permit camera and live audio video coverage of a trial in the trial court's discretion. Texas courts have repeatedly used that discretion to keep even the most charged criminal trials fully open. In the 2019 Dallas County murder trial of Amber Geiger, y'all remember the lady that I said got 10 years in Dallas County? She claimed that she thought it was her apartment, but she walked in and saw John and she shot him and he passed away. I should have just kept reading it. In 2019 Dallas County murder trial of Amber Geiger, a police officer, the trial court permitted the entire proceeding to be live streamed from the courtroom and the public watched in real time. Only months before the trial, the first criminal trial arising from the Uvalde school shootings response was moved to a Corpus Christi courtroom, chosen in part for its capacity to hold the parties, the victims' families, and the national media, and was kept open gavel to gavel by live stream coverage, a designated media room, and overflow space during jury selection. These occurrences and public character of these proceedings are documented in widely available reporting. So you have all of these cases that have taken place over the years that had open, and the Uvalde school shooting, that's involving minor babies. That was an elementary. That's crazy. But you cannot accommodate the people in Collin County. The nationally watched murder trial of Derek Chauvin is a useful illustration. Every factor a court might invoke to justify restricting access was present there. Extraordinary public interests, witness safety concerns, and pandemic limits on in person seating, yet the court did not exclude the public. When the state proposed to rely on overflow courtrooms and closed circuit cameras instead of broadcast coverage, the court rejected that proposal as inadequate, holding that audio and video coverage was the only reasonable alternative to ensure a truly public trial. And if you don't know who Derek Chauvin is, that is the individual who unalived George Floyd. The court authorized the entire trial to be broadcast and live streamed, declining only to show juvenile witnesses or the victim's family on camera. What the world? The contrast with this case is stark. The overflowing viewing by closed circuit feed that the Chauvin court deemed the unconstitutional floor and found inadequate standing alone is more than this court ever provided. For here, there was no feed of any kind. The principle holds even where broadcast is forbidden. The federal courts prohibit photographing, and broadcasting any proceeding from the courtroom. So we know that's because that's federal level. Yet they keep even their most security-sensitive prosecutions open by first come, first served, seating in overflow rooms carrying live feeds inside the courthouse. The January 6th Capitol cases and the Boston Marathon bombing trial proceeded in open court with the press and public present. And in the marquee federal trials, those main courtrooms could see only a fraction of the public. The prosecutions of Samuel Bankman Fried and I can never say that girl, Jeffrey Epstein girlfriend, among them, the court's open overflow courtroom carrying live feed, and in Maxwell's case, a nationwide live audio feed so that the bar on broadcast became no bar to access. A no camera state form did the same. In a nationally prominent 2024 New York criminal trial, where state rules forbid cameras, the court kept the trial open through an overflow room carrying the proceedings on a closed circuit television. What none of these courts did, facing public interest and security concerns equal to or greater than those present here, was admit the public for a single 10-minute window, bar reentry, and then deny an overflow room audio feed or video access whatsoever. So as big, now those were some national attention, cases, but yet they still considered the public, whether it was through audio, an overflow room where they can listen to it, or whatever the case may be, they still made an alternative. These comparators are not controlling authority, and they are not offered as such. These are offered for the limited practical point that reasonable alternatives were familiar, available, and not speculative. In none of these proceedings, however intense the public interest or acute the asserted security concern, did a court write a 10-minute window of public access into an order. And in none did a court, having set the terms of access, then deviate from its own order by withdrawing the overflow feed it had earlier provided. That is what marks this case as an outlier rather than an example. The occurrence and public character of these widely reported proceedings are matters potentially subject to judicial notice. And that's out of Texas Rules of Evidence 201, and the legal sufficiency of the ground does not depend on them. It rests on Waller, Stedman, Lilly, Presley Cameron, and the Texas emergency orders already cited. The comparators confirm what these authorities require: that overflow seatings, audio access, video feeds, and adequate courtroom space are ordinary means by which court keeps high-profile trials open, and that the court adopted none of them, confirming that its closure would neither narrowly tailored nor the product of the consideration of reasonable alternatives that Waller requires. The same picture emerges from the trials the public has actually watched in recent years. The variable that set the proceedings apart was not whether cameras were allowed inside the courtroom. Some permitted them and some forbade them, but whether the court supplied a reasonable alternative to exclusion, an overflow room, or a live audio video feed. A camera in the courtroom is not constitutionally required. A reasonable alternative to closing the doors is. Every one of those proceedings supplied that alternative. This trial supplied no continuing overflow room and no audio or video access during testimony or punishment. The following comparison offers an illustration only, sets the recognizable proceedings beside this. So Derek Chauvin, Amber Geiger, Uvalde in the New York criminal trial. In courtroom cameras, everybody permitted except for the New York criminal trial. The alternatives, so Derek Chauvin, entire trial was broadcasted and live streamed. States overflow only proposal was rejected. Okay, because so they did have an overflow policy or proposal, but it was rejected because it was inadequate. Amber Geiger, trial live stream and carried by local news. Uvalde, live stream, had a designated media room, overflow space during jury selection. The New York case, overflow room carrying the proceedings on closed circuit television. Was the public informed that in any of these trials? Yes, they were. For Karmelo Anthony, we were not. Oh, they got a whole bunch right here. This case, so compared to all of these cases, cameras permitted if authorized, none used to carry the proceedings. Overflow was offered, but then withdrawn. No overflow room, no audio, no. So y'all can compare this and you can see. Now the Amber Geiger case, that was a big case. Derek Chauvin, that's the George Floyd case. The school shooting in Uvalde, Texas, that was big. So if they can permit certain things in the courtroom and have alternatives, if they cannot, what makes this case different than any of those other cases? The trial's judge on subsequent public statements confirmed both the breadth of the closure and the availability of alternatives he declined to employ. In a televised interview after trial, a recording of which is filed conventionally with the clerk as Exhibit 4 and a verified transcript of which is attached as Exhibit 3, the judge stated that his courtroom held 77 seats. So we have it on record what he said in those interviews. So anybody can be like, well, he didn't say this. Well, we got the transcripts and I can post them so you can read them yourself. The judge stated that his courtroom held 70 seats, that he had received 200 requests by the media, and that the general public was left with only 27 to 32 public seats that they rotated every single day, but we know that's a lie. Figures that corroborated the declaration's account of roughly 27 public seats and confirmed that the press was accommodated while members of the public were turned away. The judge further acknowledged that an audio feed was feasible, stating that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it. Those was his words. And that he declined to do so not for any reason bearing on the fairness of the trial or the safety of participants, but because, in his view, people are going to distort whatever happens. And so, what's the point? This shit is about to come bite him in his ass. The whole offered as decision makers on account, these statements corroborated the closure was broader than necessary and that the court rejected a reasonable alternative for the public trial guarantee does not contend something like that. Step back, and the regimen the order created has no precedent in Texas criminal practice. A standing Trial-wide order rationed the general public to a single 10-minute entry window and roughly 2 dozen rotating seats. Capped attendance behind a media allotment, barred re-entry once the doors closed, and after a brief experiment with an overflow feed during the jury selection, switched that feed off for testimony. All while the reporters' records of the trial remain unsubscribed. Oh, I'm sorry, untranscribed. The pretrial proceedings were not made of any reporters' records available to counsel, and the case file sat in the court chambers. No Texas court has approved such a regimen, and the court's televised interview does not soften that picture, it sharpens it. Asked to account for the restrictions, the court did not point to a single record finding, an articulated threat, or a considered rejection of alternatives, the things Waller and Presley require, but defended the result as an easy decision it had struck pretty well, and explained its refusal even to audio stream the trial on the ground that people are going to distort whatever happens, so what's the point? That is not the voice of the court exercising the special care the Sixth Amendment demands before the court is closed. It does not supply the contemporaneous record support findings that the Sixth Amendment requires. The public, the public trial right is not satisfied by closing the courtroom and explaining the choice on television afterwards. It is satisfied by findings, by the consideration of reasonable alternatives, and by an open door. Thank you for sending that. I don't even know. It's just showing on my screen. That's dope. That is really dope. Thank you. Thank you, LP. The judge's own statements, see, and this is where he put his foot in his mouth. The judge's own statements of his purpose confirms that the closure was a deliberate denial of the contemporaneous public access the Constitution guarantees. You're not, see, what's happening is these groups of individuals, they feel that they are more superior than the freaking Constitution that their forefathers put in place when they brought their ass over here. When you have a whole president that feels like he does not have to abide by the Constitution of the United States, how patriotic is that? And everybody just follows suit. In a written statement to Fox News after the trial, the judge explained, "I understood the public's desire to know what happened in the courtroom. The overwhelming focus of my rulings regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency." You want to provide transparency after the trial is over? We want to know what was going on during the trial. We want to know if you was transparent during the trial. That is an admission that the public access was restricted during the trial and that transparency was withheld until the trial was over. But the public trial guarantee secures the public's right to observe the proceeding as it happens. It is the contemporaneous openness of the trial, not a retrospective account offered after verdict and sentence, that assures the proceeding is conducted fairly and discourages misconduct. Transparency furnished after the trial has ended in no substitute for an open trial and cannot cure the denial of access while the proceedings was underway. The interests the judge invoked, protecting the process, witness, and jury, are, moreover, precisely the kind of generic, non-particularized concerns that cannot justify closure absent specific findings on record. Boy, that's what I am saying. Melo's appeal team is truly playing three-dimensional chess while Mike Howard played Uno. Yep, remember he did a vid expression why it's best not to be a dog in the courtroom, but instead agreed, okay, clock it. Ain't that what they say? Clock it. The court's own public information officer independently confirms both the breadth of the closure and the existence of a simple alternative the court declined to use. By email dated June 5th, 2026, Steve Stoller, whom the 296th District Court appointed as the public information officer for this trial, explained the court's media and access process to a member of the public who has sought to attend. Mr. Stoller confirmed that the courtroom held only about 70 seats, that the prosecution and defense each received 15 seats for the family, that the judge allotted only 9 seats for the media, including one for the courtroom sketch artist, and that after court staff, only about 24 or so seats for the general public remained, so that the court had no choice but to turn members of the public away. Most pointedly, Mr. Stoller stated without qualification, there is no overflow room, nor was the absence of an overflow room an ad hoc response to conditions that emerged at trial. Baby, they appointed this man and didn't even train him on what to say and what not to say. By email dated May 25th, 2026, before the trial began, the public information officer had already advised an inquiring independent journalist that there would be no overflow room during the trial. This despite the county's own media request intake form, which listed overflow room access among the other accommodations that could be requested. The decisions to deny the excluded public any alternative means of observation was thus made in advance of trial, before any day's circumstances existed that could have justified it. You know, the crazy thing is, so on the media request intake form, and you know what? Let me see what that form looked like right quick. I'm on page 37. We almost done, y'all. Exhibit 8. So you have an option for the overflow room. So this is it: outlet, contact, media request type. So you have, so these options right here, that means that they are available, right? If I check overflow room access, I better get overflow room access. This is crazy. Lawless Collin County. That's exactly what it is. The decision to deny the excluded public any alternative means of observation was thus made in advance of trial, before any trial day circumstances existed that could have justified it. The 15-seat family allotment the public information officer described was not how family access operated in practice. The defendant's own family was limited to 8 seats in total, so that the defendant's grandfather and aunts were excluded from his trial altogether. The discrepancy is not a conflict in defendant's proof, it is the proof. The written order disclosed no numerical family allotment, no public seat allotment, no defense family limitation, and no procedure for challenging exclusions. The public information officer's later 15-seat description and Ms. Thompson, I hope I'm saying that right, 8-seat account, show the material access rules were being administered outside the written order and outside open court. Because if that order says, okay, 15 seats, we need to have 15 seats. Set beside the judge's own admission, the picture is complete. The judge acknowledged that an audio feed was feasible, stating that he sometimes thinks that maybe he should have at least audio streamed or something so people can hear it, and then declined it not only for any reason bearing on the fairness of the trial or for the safety of participants, but because in his view, people are going to distort whatever happens. Like, okay, so in other words, for the slow people out there, if he would have said, I did this because we wanted to ensure that the people that participated were safe, or we wanted a fair trial. He did not say that. He said because he felt that people was going to distort whatever happens. The court thus faced a courtroom that could seat only about 24 members of the public, with no overroom flow and readily available alternative piping the audio so that excluded public could at least hear the proceeding that the court itself recognized and yet refused to employ. That is the opposite of obligation to take every reasonable measure to accommodate public attendance, and it confirms the failure to consider the reasonable alternatives that Waller requires. These omissions do more than corroborate the breadth of the closure. They reveal the considerations that actually drove it, and those considerations cannot satisfy Waller. The first factor demands an overriding interest likely to prejudice by an open courtroom. The decision maker's own account, however, locates the basis for the restrictions outside the record and outside any such interest in the volume of media attention, and by his stated reasons for refusing an audio feed and his expectation that the public would distort whatever happens. A desire to limit the public's ability to observe and judge a criminal proceeding for itself is not an interest that justifies closing the courtroom. It is the very harm the open trial guarantee exists to prevent. As the Supreme Court has explained, open proceedings exist so that the public may see how justice is done, for it is difficult for them to accept what they are prohibited from observing. A desire to avoid public misunderstanding or distortion is not, on this record, the kind of overriding Waller interest that can justify excluding the public. It is one of the reasons the public trial right exists. The closure therefore fails the first and second Waller factors on their merits, not merely for want of adequate findings, and the resulting violation is structural. Where the record fails to show that the trial court considered all reasonable alternatives to closure, the closure is reversible error. Off-record administration by non-judicial personnel confirms that no Waller determination was made. The court could use staff, deputies, and a public information officer to assist with logistics, but Waller required the court itself to make the constitutional access determination on the record. That did not occur. The amended order did not merely regulate the quorum, it created a scarcity regimen for a public criminal trial, limited public admission, space available seating, a media cap, closed doors at 9 a.m., restricted reentry, no continuing overflow, no audio, no video alternatives for jury selection. Yet the order did not disclose the number of public seats, the number of family seats, the standard of determining media, or any process for challenging exclusion. In practice, those decisions were administered through courthouse personnel and the court-appointed public information officer. The officer later described numerical allocations that do not appear in order. Members of the public were turned away or removed under standards that do not appear in the order, and requests for alternative access were routed by email and denied outside any judicial proceedings. The resulting record does not show who was excluded, why exclusion was necessary, what standards govern admissions, or what alternatives the court considered. Defendant does not contend that every logistical action by court staff is unconstitutional. The defect is narrower and more serious. Access decisions with constitutional consequences were administered off the record, without published standards, without judicial findings, and without a viewable ruling. That confirms the Waller violation. Defendant further preserves the argument that, to the extent the amended order delegated the constitutional access determinations, Waller commits to the court, rather than mere logistics, that delegation was itself unlawful. Boy. The court's off-record sealing of record was unlawful and harmed the defendant. All right. The secrecy did not end at the courtroom door. It reached the court record itself. Beyond the gag order that silenced the parties, counsels, and witnesses, the court directed that motions and subpoenas be hand-delivered to the court and held under seal, and the court, not the district clerk, y'all. The district clerk office is different than the actual court. The district, not the district, the court served as the custodian of the case file, which was kept in chambers rather than in the district clerk's public file. No public order authorizing that arrangement, supported by the notice, hearing, and findings the law requires before a record may be sealed, whether was it ever entered. The docket nonetheless reflects a series of orders restricting the record in order to redact. There was an order to file and redact, and an order to reseal. Order to seal. And then a further order entered on June 18th that the public docket leaves undescribed. Yeah, I hope so. I'm really praying that I'm praying that he does, get out and do what he needs to do, because I know it's hard on him, and I've always said that the justice system was not made for us at all. It can apply to everybody else, but when it's black and brown, and this is just being in this field and seeing it, it is not made for us. I'm just going to, be truthful about that. The filings in this high-profile prosecution were thus unavailable for contemporaneous public inspection in the ordinary course. The sealing was not confined to particular findings. The entire court file was placed under seal by oral order, with no written order, no public notice, no open hearing, and no findings to justify withholding the record from public view. The breadth and basis of that order are confirmed by the court's own statements. At a conference held on June 29, 2026, the court advised the parties that the entire court file had been sealed by oral order, and that the counsel could not access the file unless he agreed not to disclose what he observed in it. And it's crazy, because just like I told you at that email, when I tried to get the documents, they told me that I can get a copy of the motion to recuse, but I couldn't get a copy of the retrial, the new trial, the motion for retrial. And I wonder why that is. But baby, we got it. Counsel responded that he could not commit to withholding information he had not yet seen, and the court left the file available for inspection only in court chambers. The episodes lays bare the character of closure. Access to the record of a public criminal trial was conditioned on a promise of secrecy that no responsible advocate could give, and the file was kept, quite literally, in the judge's chambers, beyond the reach of public and of the defense alike. An oral order sealing an entire court file pronounced without notice, hearing, and findings is sealing in the least viewable form. There is no order to contest, no findings to test, and no record for the decision to seal at all. This continuing denial of access to the file is a piece with the disclosure of the courtroom itself. Both withhold the opening proceedings the Constitution guarantees, and both confirms that the secrecy was structural rather than incidental. And like I said before, I'm pretty sure this is criminal court, or it don't even matter what type of court it is. You're going to have proceedings almost every day. And I need to check his docket to see if he even had a proceeding like the next day or whatever. So you still have this file, this big old case file in the courtroom. I'm not understanding why. There is a process that you have to do. It has to go to the court clerk, the district clerk. So it doesn't make sense to me that and obviously they sent this on the 7th. They filed this yesterday, meaning that, like they said, the court reporter transcript has not been transcribed yet, and the case file is still in the judge's chambers as of today. Why? And you're telling counsel now that if you look in this, you can't tell anybody what's in this. So what's in this that you don't want the public to see? The public and the press hold a constitutional right to access to criminal proceedings and to the records of those proceedings, and a court may not seal the record of a judicial proceeding in secret. And this just popped up in my head. So you still have the file in. So after the court concluded on June the 9th, right? Now, just maybe I'm the slow one. Maybe I'm slow. So, and people are out there not understanding. So you telling me, and I think at this point he doesn't care, because you go and do an interview and you can't say that you did not know that there's a time period in which a motion for a new trial can be filed. Right? So you can't say that you didn't know, because what would be the reason that you still have the whole file in your chambers? What would be the reason that the court reporter has not transcribed that transcript? That's the question that I have. That's the question that I have. Oh, excuse me. This is crazy. We have a right to see what's in there. The right of access is a fundamental element of the rule of law, and a court's discretion to seal its exercise charily only after it identifies and balances the competing interests on record. Sealing without public notice and an opportunity to be heard itself is unconstitutional. A court may not maintain a file or docket that hides filings from public view. Had to get my ice. In Texas, the right to access in Texas, the right of access is both constitutional and statutory. It's a law. There's law and there's a statute. The open court's guarantee of the Texas Constitution and the command of the Code of Criminal Procedure that the proceedings and trials in all courts shall be public, secure the public's access to criminal proceedings and to record records generated in them. I'm glad that I'm reading this so everybody can understand what we have. We have rights as citizens. This is the United States of America. Okay, we're in a democracy. We are the people. That's what the founding fathers said. We are the people. The open courts guarantee the Texas Constitution and the command of the. Oh, I already read that. The records of a criminal case are therefore presumptively open, and a court may not seal or sequester them without public notice, an open hearing, and specific findings. Although Rule 78A governs civil court records, the same principle of public access applies with full force in criminal proceedings. The defendant relies on the criminal open guarantees, not Rule 76A, as the governing law. The court honored none of these requirements. It sealed and sequestered the record without a public motion, without notice, without an open hearing, and without findings sufficient to justify withholding the file from the public. Taken one at a time, each of these measures might be debated. Taken together, they accomplish what the law forbids by any route, a proceeding materially closed in operation. The general public was rationed to a 10-minute entry window and a rotating handful of seats. The press was capped, and the remaining public turned away. The overflow feed was switched off when testimony begun. Substantial pretrial hearings went unrecorded. A gag order restricted the covered persons who might have described what was happening, and the case file itself was drawn into chambers and sealed by oral command, without notice, hearings, or findings. The through line is not any single ruling, but a consistent effect. Public access was materially restricted through written limitations, off record administrations, and record uh, uh, sequestration. That is the structural injury the public trial guarantee exists to prevent. A proceeding conducted under these conditions is not an open trial marred by isolated irregularities. It is a proceeding materially closed in operation, and the deprivation it complete the moment members of the public are excluded without Waller findings, regardless of whether the outcome would have been different. The record sequestration did more than offer the public's right of access. It directly harmed the defendant. The period after judgment was marked by a rapid succession of counsel. On June 10, 2026, trial counsel withdrew, and the court appointed appellate counsel, who was then replaced by a newly appointed appellate counsel before the defendant's present counsel were substituted in on June 23rd. Throughout that period, and while the 30-day deadline for a motion for a new trial was running, the materials necessary to evaluate and prepare the motion were held by the court in chambers and were absent from public file. And that, you know what? That is why Mike Howard submitted that affidavit. Because if the court file is still in the judge's chambers, they wouldn't have any way of knowing exactly what went on in that courtroom, what was filed, who testified, so on and so forth. Because one, the court, damn, I can't talk. For one, the file is in the chambers. For two, you can't go off the transcript because it hasn't been transcribed. So in order to do this motion, how can you do this motion if you don't have anything to work with? So they had to rely on Mike Howard's affidavit. They had to rely on the affidavit of the members who were turned away from not being able to go into the courtroom or the court proceedings. They had to rely on that. And that's crazy. Each successive counsel was thus required to come up to speed. And I need to start reading, but my mind is turning. Each successive counsel was thus required to come up to speed and to prepare against a hard statutory deadline in an incomplete and inaccurate record. The reporter's record could not fill the gap. When counsel contacted the official court reporter, counsel was advised that no portion of the trial had been transcribed. Counsel was thus left to prepare this motion with neither the pleadings and the case file held in the court's chambers nor any transcript of the proceedings. The public docket, for instance, reflects no motions of limine and would suggest to any reader that no substantive pre-trial litigation occurred. An impressive, the sequestration of the file left no fair opportunity to test in the time allowed, because this was actually due. The 90 days is up, tomorrow? Not 90. The 30 days is up tomorrow or the next day on the 10th. So in order for them to, so that's why it took a very long time for this motion for a new trial to be filed, because they don't have the docket. They don't have any of the records that were on the docket. And some things, such as the motions of limine, the pre-trial documents weren't even filed. That is crazy. And then on top of that, they don't have anything, they don't have nothing from the court reporter. So they are literally going off of what Mike Howard said and what the people who were actually, present in the courtroom for a short period of time, what they said. But majority of it came from Mike Howard. Their intent for Karmelo is to have a court-appointed appeals team. Exactly. I do believe that. I strongly do believe that. Dred Scott, black people were considered an inferior order who had no rights which the white man was bound to respect. Sounds like this judge is... Ciao. All right, let's get back into this, y'all. Where did I left off? The public docket, for instance, okay, I already said that. By withholding a record during the very window in which the defendant and his changing counsel had to identify and develop the grounds for relief, the court's unlawful sealing compressed the defendant's effective time and deprived him of the complete and accurate record to which he was entitled. So, in my opinion, based off of what I am reading, they tried to sabotage this case. They didn't think, like someone said, they really tried to sabotage this case because they thought that a court-appointed attorney was not going to do justice because, one, they're in a lawless county. The defendant's entitlement to a new trial. Oh, I hate when it does that. The defendant's entitlement to a new trial rests on his Sixth Amendment right to the public trial. The court's off-record sealing confirms the public access was materially restricted in both the courtroom and the case file, and that the restriction was structured rather than incidental. And by impairing the defendant's ability to prepare this motion on a complete record, it works a distinct unfairness, and that reinforces the need for relief. The resulting violation is structural. I read this so I can help you guys understand, because I saw a statement, I'm just going to say it. Miss Sarah J. Fields said that she spent half her night reading this, and she said that, in her words, it was a bunch of BS. And that lets me know that you don't understand the process and you don't understand the laws of the state of Texas and the very state that you live in. The very state that convicted you, well, I don't want to say convicted. Well, did you get convicted? I don't know. But you was arrested by the state of Texas and you went through the courts through the state of Texas. So had it not played out in your favor, because these same very rules that we're talking about now apply to that case that you had. So if you feel that there was, that this is not going to work out, I don't know what you're reading. And it's evident that you don't understand the law. No documents, no legal records that can be reviewed by the appellate court. Would this cause the appeal to be denied? That's a very good question, and no. So the way that, how can I say this? So the first step is obviously to file that notice of appeal to get that started. So once he filed the notice in trial court, it's then sent to the Fifth Court of Appeals or to whatever appeals court in that district. As far as the trial, so it's two separate things that's going. You got the appeals court, and then you still got stuff happening in the trial court. So once a verdict is reached, or judgment, however you want to say it, you have 30 days to file your appeal, a motion for a new trial, and obviously they filed a motion to recuse. Okay, and as far as that part goes, the attorneys, the appellate attorneys, while they are working on this motion for new trial, you have to have those records. So I've never seen a case where none of the case files was available and a transcript has not been transcribed. It has been going on 30 days. Now, it's different if you say you're working on it and it's going to be because you actually have to file it. Because I already know in the on the Fifth Court of Appeals side, you have a deadline in which the clerk's record and the court reporter's transcript has to be filed with the Fifth Court of Appeals. And in the event that there's a delay, you have to actually file a um, a pleading or a notice just saying, hey, we would like additional time because we're getting. And I think I pulled up a case. What was it? Kaysen Allison out of Bell County. You can see on their docket that shows the court reporter was saying, I need more time. I'm still preparing. I need more time, so on and so forth. So Collin County is deliberately doing this. They are deliberately doing this. Will that means his appeal going to be denied? No, because your appeal, it goes through a process. So once the court reporter transcript and the court clerks, the trial clerks records have been submitted to the Fifth Court of Appeals, those are then sent to the appellate team. So the dream team will actually look over that, and then they will do their brief, submit their brief, then the appellee submit their brief. If they both request oral arguments, then they'll have the oral arguments hearing, and then the panel, the appeals panel, will review the briefs and the oral arguments, and they'll make their decision. And that's when they will determine whether, the ruling of the lower court is going to stay or if it's going to be overruled or turned. So we have a long time before we even get to that part. But it's a requirement that those records and that transcript go to the Fifth Court of Appeals. So it's just because it doesn't reach that does not mean that it's automatically going to be denied. They're going to put pressure on them to get those because you can't work the appeal if you don't have those records. Yes, it was done on purpose. It was done on purpose. No, it's not. The records are in the chambers, and the court reporter ain't even transcribed the whatchamacallit. So they're doing this on purpose. Yeah. Yeah. So I hope somebody step in real quick. I hope somebody steps in. I'm glad to see these step up. The average appellate attorney would have a snowball. Yep. Yep. I hope so. But this is Collin County that we talking about. So I don't know what their plan is. I don't get it. All right, let me get back into this because baby, I need to wrap this up. I'm getting sleepy. Um, what did I say? Okay, the defendant's entitled to a new. Okay, the defendant's entitlement to a new trial rests on his own Sixth Amendment right to the public trial. The court's off-record sealing confirms the public access was materially restricted in both the courtroom and the case file, and that the restriction was structural rather than incidental, and by impairing the defendant's ability to prepare this motion to. I already read that. On a complete record, it worked at a distinct unfairness that reinforces the need for relief. The resulting violation is structural. The gag order reinforces the need for a hearing and shows the cumulative restriction of public access. All right, I'm going to power through this. Defendant does not seek in this motion to litigate the public's or the witness's independent speech rights in the abstract. Defendant relies on the gag order because together with the access restrictions, the record sequestration, Lord, it limited contemporaneous public understanding of the proceeding and underscores why the denial of public access was not harmless, trivial, or curable after the verdict. The physical closure did not operate alone. From July 28, 2025 through the verdict, every person with firsthand knowledge of this case, the parties, the attorneys, the witnesses, expert consultants, agents, spokespersons, law enforcement, and court staff was forbidden on pain of contempt from making any statement that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness, or that intends or is likely to influence public opinion or potential jurors. A prior restraint of the breath is presumptively unconstitutional under Article 1, Section 8 of the Texas Constitution, which provides greater rights for free expression than its federal equivalent, and it survives only upon specific findings supported by evidence that one, an imminent and irreparable harm to the judicial process which deprive litigants of a just resolution of their dispute, and two, the judicial actions represent the least restrictive means to prevent that harm. And I do want to take a shout out and give it to my mods, and hey, if y'all gotta go to bed, I truly understand. I'm not going to be mad at you. I can hold it down because I know it's getting late, but shout out to my mods. Let's see. The July 28th order findings failed that test on their face. A finding that media coverage has the potential to cause an imminent and irreparable harm is a finding of possibility, not imminence. The speculation Davenport forbids. No evidence is no evidence is recited, none was heard. And the finding that venue change, juror screening, and sequestration would be inadequate alone concedes the point that decides the issue. The alternative existed, and the court knew them by name. Indeed, it went on to employ two of them, screening the veneer through written questionnaires and sequestering the seated jury. The latter widely reported and to be confirmed at the hearing. A restraint is not the least restrictive means where the court order catalogs the lesser tools and the court own trial deploys them. That the order issued a sua sponte and no party's motion with no evidence offered by anyone completes the failure. And in the 10 months it operated, not a single violation was ever alleged. So far as the record reflects, the imminent harm never once threatened to materialize, and the post-speech remedies Texas law refers were never needed. The absence of enforcement is not the absence of injury. A prior restraint does its work through obedience, and here it was obeyed. So there was nothing outside of the ordinary that happened. The order's fourth prohibition severes the restraint from its only asserted justification. The findings speak of jury impartiality. The prohibition reaches any statement likely to influence public opinion. Public opinion generally, jurors or no jurors, for nearly a year in any public medium. A witness who professed the defendant's innocence to a reporter, a family spokesperson who questioned the prosecution, a court-appointed official who described the access restrictions themselves, each spoke on pain of contempt. Whatever latitude, Gentile versus the State Bar of Nevada, affords the regulating attorney's speech under a substantial likelihood of material prejudice standard, that latitude, no application to lay witness and spokespersons, and no standard known to Texas or federal law permits gagging commentary addressed to public opinion as such. And the restraints interlock with the rest of the design. The gag order's sole safe harbor, procedural announcements such as hearing schedules, court filings, presupposed a public docket. The court then sealed the filing by oral order so that the safe harbor described documents no member of the public could read. The gag order itself, meanwhile, provides that it yields only to further written order of this court. Both restraints, moreover, issued a sua sponte. No party asked the court to silence the participants, and no party asked it to restrict the courtroom. The gag silenced those with knowledge. The access order excluded those who sought it. The sealing erased the paper trail. And each measure recited defendant's fair trial rights, while the defendant's actual trial was conducted beyond meaningful public review. The July 2025 order matters to Waller analysis for a further reason as well. It proves the court knew the less restrictive toolkit listing venue change, jury screening, and sequestration by, by name 10 months before the trial. And when the time came to restrict the courtroom itself, the court considered no alternative at all. Oh, how many we got going? Hold on, let me see. Because, baby, we talking about I'm getting tired. Oh, damn, did we already go through the second grant? Oh, hold up. I'm going to go through this. Point out the whatchamacallit. A closed courtroom. All right, so a closed courtroom is structural error. What this one says. So this, okay, I already read that. So another reason a closed courtroom is structural error that only a new trial can cure. So a violation of the right to a public trial is structural error that is not subject to a harmless error analysis. Because the closure pervaded every stage of the proceeding at which the order applied, jury selection, the guilt innocence phase, and the punishment phase, rather than a discrete and ancillary hearing, the appropriate remedy is a complete new trial. A structural error that is preserved and timely raised entitles the defendant to relief without showing of prejudice. In the alternative, the court should conclude that any error affected only the assessment of punishment. Defendant requests a new hearing on punishment. Defendant had no earlier opportunity to object, and this motion preserved the claims. That, because I was wondering where the hell, why he didn't object to anything. As a general rule, a complaint must be raised by a timely objection in the trial court. That requirement, however, assumes that the appellant had the opportunity to raise it there. Where a defendant has no opportunity to object to the trial court's actions until after the action is taken, a timely motion for the new trial preserves the error. So that means that, like, just like the no overflow room and all that other stuff, like, you didn't say that in open court. You said that behind closed doors or through an email. So, at that time, that is something that, if they said, okay, we didn't want any cameras and no other members of the public to be, in the courtroom and all that other stuff. That should have been in the courtroom, because Mike could have said, well, I object to that. I feel that these people should be here. I feel that we should have cameras in the courtroom, so on and so forth. But that didn't happen because it wasn't addressed before the court. Child, they did some shady behind stuff. Let me see. Who administered credentialing, blah, 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 denied access. So that public information officer denied access and denials of access off record. I'm scheming now. The point is underscored by a proceeding that unfolded outside the defense knowledge. Before trial, a member of the public filed an emergency petition of writ of mandamus in the Fifth Court of Appeals seeking relief from the same access order as an unconstitutional partial closure. The Court of Appeals denied that petition on procedure grounds on June 4, 2006, the first day of testimony and the very day the overflow accommodations were withdrawn. On his motion for reconsideration, the realtor served the district attorney in the trial courts, but by his own account could not serve the defense because he lacked counsel's email address, and the appellate court's own notice of the proceedings were directed to the district attorney, not to Howard. The defense. Wait a minute. Whoa. All right, we're going to take this back because that's something right there. let me reread this section because I think this is important. Hold up. The complaint cannot have been preserved by the contemporaneous objection for two independent reasons. First, the constitutional violation lies not in the text of the amended order alone, but in ways the access regimen operated in practice, a regimen that, as accompanying declarations show, excluded the public far more severely than orders terms disclose. That operation unfolded outside of the courtroom, at the courthouse entrances, and in the pre-dawn lines administered by the sheriff's deputies and the public information officer, where trial counsel seated inside the courtroom and attended to trial could neither observe it nor measure its scope. Counsel had no way to know from inside the courtroom how many members of the public were being turned away, that the overflow accommodation used during jury trial selection had been withdrawn, or that admission was being administered without standards. Second, the access determinations were not made by the court in open court on a record to which an objection could attach. The court delegated them to the public information officer and the courthouse staff, who administered credentialing, line management, and denials of access off the record. There was no ruling for counsel to object as it occurred, nor did the amended order's text put counsel on notice that a closure would occur. The order recited that the media and public retain the right to attend proceedings and promised reasonable public access consistent with constitutional requirements. It nowhere disclosed the allocation of seats that would leave the general public roughly 24, an allocation that appears in no order and that surfaced only in the public information officer's June 5th email. Well, I'm glad he put that in there because otherwise we would not have known because it's not on the transcript because the court they didn't do it before the court. And the court began the trial by performing its promise, furnishing an auxiliary viewing room through jury selection. Counsel was entitled to take the court's order at its word. The closure crystallized only when the accommodation was silently withdrawn without announcement, ruling, or modification of the order, and when admission came to be administered at the courthouse entrances and in pre-dawn lines that counsel brought in with parties through a separate secure entrance never saw facts the evidentiary hearing will establish. The full scope of the closure became apparent only after trial, when present counsel obtained the declarations of members of the public who had been excluded. So Mike Howard didn't even know what was going on. He didn't know people were getting turned away. Well, members of the public was getting turned away until he started getting declarations from. That is wow. The point is underscored by a proceeding that unfolded outside the defense's knowledge. Before trial, a member of the public, so before trial, a member of the public filed an emergency petition of writ of mandamus in the Fifth Court of Appeals seeking relief from the same access order as unconstitutional partial closure. The Court of Appeals denied that petition on procedural grounds on June 4, 2026, the first day of testimony. Oh, that was Christopher King that did that. I need to talk to him. So you the one who did that. Okay. On his motion for reconsideration, the realtor served the district attorney and the trial court, but by his own account, could not serve the defense because he lacked counsel's email address, and the appellate court's own notice of proceedings were directed to the DA, not to Mr. Howard, the defendant's attorney of record, who received no notice of it. Notice facts that appear from the court appeals docket and that hearing will establish. The public access challenge was pending and litigated as trial approached and proceeded, and the state was on notice of it while the defense was left unaware. That a member of the public was contesting the very closure at issue, and the state knew of it while the defense did not. Both corroborates that the closure was real and confirms that the defendant had no opportunity to litigate or object to it as it unfolded. The record of the proceeding is, moreover, among the materials in the court files that the court has placed under an oral protective order, so that the proof of who was and was not notified is itself withheld from inspection, a further reason these facts must be developed at hearing. So, okay, so I believe Christopher King, if y'all don't follow him, go follow him. He filed a he pretty much was saying, hey, like, we need these documents because they are public records, and they denied them to get that. So he filed the motion for consideration, but I don't know if he did it through the e-file system or what, but normally it will have all of the address that of everybody that you will serve, the DA, the counsel, if the parties have email addresses, but normally if they have counsel, then we won't email them. But it's funny how it did not have, it had the DA's email address, but it didn't have Mike Howard's email address, because normally you'll just do it through the e-file system and it'll go to all parties. So either way, Mike Howard was clueless. You're welcome, LP. Good night, good night, good night. Yeah, that's wow. That is wow. So he did that. So all of this is considered a structural error. The structural error is thus preserved and timely raised. The defendant is entitled to a new trial without a showing of prejudice. To the extent the court concludes that a contemporaneous objection was nonetheless required and not excused by a manner in which the order was imposed, the alternative grounds set out below independently preserved and established a claim. So, in other words, because they did not allow, because a lot of stuff was done behind closed doors and not done before the court, that did not allow for Mike Howard to object to that, like the turning away of members of the public, because otherwise he's saying he probably would have objected, but we don't know. But we know he did not have the opportunity to object to anything. So that is considered a structural error, and because it's a structural error, that should entitle the defendant to a new trial. Oh, okay. Okay. Well, thank you, LP. I thought you was going to bed because, child, I need to go to bed. It's 12:11. The trial court's independent obligation to protect the public does not diminish, just showing the two principles operate at different planes. Presley fixes the court's substantive duty to consider reasonable alternatives and to make adequate findings before closing any portion of the trial, and to discharge the duty even on its own motion. Dixon characterizes of a public trial that as forfeitable addresses only preservation, the procedural requirement that the defendant assert the right to obtain appellate review, not the existence of court's duties or the occurrence of a violation. Oh, and both are satisfied here. The court closed the courtroom on its own motion without the findings or the consideration of reasonable alternative that Presley requires, and the defendant asserted the right at the first opportunity the closure afforded to him. So in summary, the grounds and facts supporting a new trial on the first ground are these. The trial court materially restricted public access during the testimonial phase and punishments proceedings, repeatedly excluding members of the public without the finding or consideration of alternative Waller requires. The same access regimen applied across jury selection, guilt, innocence, and punishment, and it repeatedly excluded members of the public from substantial portions of the proceedings. The resulting violation is structural. The defendant had no earlier opportunity to object, and a new trial is the only adequate remedy. Should the court not find the first ground persuasive, it should next consider the second ground for new trial. So they're saying the second ground, the reason why they think they should have a new trial, is that the state's repudiation of the parties' unrecorded agreement leading character evidence after the defense relied on it, coerced the waiver of the defendant's right to testify, denied him a complete defense, and warrants an evidentiary hearing. Oh man, hold up. I'm trying to see if we can just get a snippet. Let me see what this bottom one says. All right. Okay. I'm going to read the in summary. So, in summary, the grounds and facts supporting a new trial on the second grounds are these. The state induced the defense to try its case under an unwritten agreement limiting character and extraneous offense evidence, foregoing cross examination, witnesses, and its own client's testimony in reliance on that agreement, and then repudiated the agreement after the defense had performed, coercing the involuntary waiver of the defendant's right to testify and denying him the right to present a complete defense. Because the agreement and its repudiation were placed off the record, an evidentiary hearing is required to resolve them. Should the court not find, okay, so that summed up what they were talking about. So the state did everything that they wanted to do, presented their witnesses, said what they want to say, blase, blase, blase. But then when it's time for the defense, he was limited because of this unwritten agreement that they had. And I don't even know why you would sit there and agree to that. That is still mind-boggling to me. So you really just botched this whole you botched Karmelo's whatchamacallit, because I don't like, okay, if you are I know some attorneys that are plaintiff attorneys that are friends with defense attorneys, but when they're in the courtroom, that's game time. Like when we're in the courtroom, you're the plaintiff counsel, you're the defense counsel. That's it. We're going toe to toe. This ain't got time to be like, oh, Bill, yeah, I know you, we can go out for drinks later on. No, this is not the time for that. This is the time that you have balls and you fight for your client. The third reason they're wanting a new trial is the court's unsupported provocation instruction improperly limited the defendant's right to self-defense. So I'm going to go to the whatchamacallit, because in summary, this was it. So in summary, the grounds and facts supporting a new trial in the third grounds are these. The trial court submitted a provocation instruction unsupported by the evidence, which improperly withdrew the law of self-defense. The defendant's sole contested defense from a jury's full consideration, and the error was both preserved and harmful. And I think what I might do is I probably would turn these into like little mini whatchamacallit, just in case y'all want the breakdown of each of those. The fourth ground, a new trial should be granted in the interest of justice. Finally, in an alternative, the court should grant a new trial in the interest of justice, even where no single ground independently sufficient, their cumulative effect, a trial in which the public access was materially restricted during the testimonial phase, a mid-trial repudiation of the parties' agreement that coerced the defendant's silence and gutted his self-defense presentation, and an unsupported instruction that narrowed the same defense, because they're talking about the jury charge, that deprived the defendant of the fair, open, and adversarial trial the Constitution guarantees. The court retains discretion to grant a new trial in the interest of justice where a valid legal basis supports it, and the grounds above supply that basis. Whereas, premises considered, the court restricted the general public to a 10-minute daily admission window and provided no contemporaneous alternative for those foreseeable turned away, without the finding Waller required. The resulting closure is structural error that a new trial is required to cure. Defendant Karmelo Anthony therefore respectfully prays that the court set the motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of courtroom access determination to a non-judicial officer, that public information officer, because how are you going to tell me that the overflow is closed? The parties' unrecorded agreement limiting character evidence and its repudiation, and the preservation and harm facts concerning the unsupported provocation instruction may be developed, grant the motion, set aside the judgment of conviction and sentence, order a new trial conducted in a courtroom open to the public, enter written findings of fact and conclusions of law in support of its rulings, grant the relief requested in the interest of justice, and grant such other and further relief to the defendant may justly be entitled. And that's it. And then everything is the exhibits. Yeah, we had to oh, I got you. Yes. That was a lot. I'm not even gonna lie, that was a lot. Um, y'all, I'm tired as y'all can see. That is interesting. After reading all of that, and I hope y'all got the gist of everything. There was a lot of structural and procedural things that happened during that trial that the appellate team did. Um, they called it out, and they backed it up by statutes. They backed it up by previous cases that took place in the appeals court. Me personally, in my opinion, it based off of what I have seen, the Stricker versus State, Hernandez versus the State, and that Texas Court of Appeals one, criminal appeals. I feel optimistic about this. I truly do. I feel that a new trial might be granted. And I know a lot of people don't want to say that, but based off of what this appellate, that was a very long motion, but it was very detailed, and it broke down the very thing that stood out the most. And I think with that being said, and them applying the case law to it, they have a strong argument. They have a strong argument. So yeah, thank you. Hey y'all, thank y'all for telling thank y'all for hanging in there, because baby, we started late. This case was doomed from the beginning. Neither defense knew he wasn't going to win and agree with the actions for. Yeah, and I really just don't understand why he would do that. And that's why I said I strongly believe that Bill, like Collin County, Greg Willis and Bill Worski, I think they possibly have a chokehold on these people in here. But I know some good ass the not guilty boys. I know they wouldn't mind going up against that. They will give them a run for their money. I don't believe Andrew. He been held in contempt. Like, I'm going to fight for my client, and that's what you have to do. You need to fight for your client, and Mike Howard did not do that. He literally got punked, because there's no way in the world I would go in there and pick an agreement, and then now you're mad because the judge is not giving you time to explain something to a 19-year-old. Well, that's your fault, because one, you should have had him prepared for the beginning, but two, you should I would never understand that. I would never understand it. But it's in the past. The only thing we can do is move forward, right? I believe that this is a strong motion that was written by an awesome team. Like somebody said in the comments, that's why they are the dream team, because they did that. The summary explains why they are called. Exactly. So I pray that this happens. The 75 day that put that, I think it said August 21st. I have to look on my calendar. I'm gonna make a note to calendar 75 days 75 days from 6/9. So it'd be 16 and 6/9. I'm gonna do that so I can see exactly. So within 75 days of the June 9th sentence, they have to make a determination on that motion for a new trial, in the motion to recuse. Clarity, he's going to get a new trial. I've been saying this from the beginning, just reading and looking up some things on how it's supposed to even go. Different states are different. Exactly. Yeah, different states, they have different jurisdictions and everything. But you're right. A lot of people out there, they're going to say, and that's why I try to explain. It's not about, if the conviction gets overturned, that's not Karmelo's fault. At the end of the day, everybody is entitled to a fair trial. As it said, the Anglo Americans is the one who put these laws in place. I'm just saying. They have the case they're going to get is going to be under scrutiny. I think he's going to recuse himself from the case. I think somebody said I need to check the docket. I think somebody said that he already denied it. And if he denied it, all it does is just go to the regional judge for review and consideration. So we're going to see. They were okay planning appointing attorneys and making it exactly. Yep. But we're going to see. But y'all, okay, thank you. It was August 23rd. Okay, it was August 23rd. 823. All right, y'all. So I'm about to call my boyfriend, let him know I'm still alive. But y'all, thank y'all for tuning in and hanging with me. I'm so sorry that I was late. We've been on here for damn near 5 hours, but that's okay. But at least y'all got the gist of everything. Prayers up. That's all we can do. It was based off of the laws and the statutes of the state of Texas, as well as the Sixth Amendment. They violated defendant's Sixth Amendment, but by not having an open trial. I gotta take my dog out. They're getting on my nerves. But yeah, thank y'all for tuning in. Don't forget to like, share, and subscribe to my channel. I don't know if I'm gonna do a lot of lives because this one was draining, but it was very informative, and I hope you guys learned a lot. But thank y'all. Your nails are beautiful. Oh, y'all, y'all can't see them up close, but I gotta get my nails done. But thank you. But y'all, thank y'all for tuning in. Y'all have a blessed night, and I'll probably see y'all on Friday. I don't know yet, but peace.